Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Nice to have you here. Let's start out our day. Hi, Ellie. Let's start out our day with Judge Simpson.
DISC of discovery that's apparently in the mail from the prosecutor's office to me. As of yesterday's mail, I haven't received it, but that is going to make or break this case.
Next day.
Your next date is December 17th.
Pardon me, Your Honor. Could it be the 7th of January?
Any objection from the people?
No, Your Honor.
January 7th, 2026, 9 a.m. Bond in this case will be set in the amount of $10,000 personal recognizance bond, although under standard conditions, including no assault behavior or possession of any weapons or ammunition. You understand that, sir?
Yes, sir.
There's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I would 3158 is it just this store? Madam Prosecutor, is it just the TJ Maxx?
Yes, Your Honor.
All right. I would indicate that the defendant is not to enter any TJ Maxx store in the state of Michigan. All right.
Even at Christmas time, Your Honor?
Even at Christmas time.
Very well.
Shop online.
Thank
All
you,
right,
Your Honor.
thank you. Court calls case People versus Sukhdev Singh.
Morning, Your Honor. Joseph Wagner on behalf of Mr. Singh is present in court.
State your name.
Sukhdev Singh.
Thank you. What are we doing?
Your Honor, you have a,
Do I have a plea form?
You should have a plea form for the motion, right? And
I do.
accept it.
This is the one that I did. All right. We're still going to have to deal with that.
Yeah, no, Your Honor.
All right. The plea form indicates that the defendant will be pleading to the charge of embezzlement by an agent or trustee less than $200. That's a no contest plea. The 93-day offense upon a successful plea to that charge, count one would be dismissed. Defendant also agrees to make restitution in the amount of $260. There is a sentence agreement of prosecutor's deferred sentencing.
That's correct, Your Honor.
Full understanding.
And for the record, my client would wish to change his plea to no contest.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Sukhdev Singh.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of embezzlement by an agent or trustee less than $200. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property embezzled. If that's greater than $500, that would become the maximum fine. Do you understand that, sir?
Yes, sir.
All right. Do you understand what a no contest plea is?
Whatever he explained me,
All right. Two things I have to make sure that you understand about a no contest plea. It first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Okay.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty to this offense. You understand that?
Yes, sir.
Any other questions you have regarding a no contest plea, sir?
No, nothing, sir.
All right. Basis for the no contest plea.
Civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Well, we don't-
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
You have any questions regarding any of those rights?
No, sir.
All right. Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights contained on that form.
No trial. You understand that? So yes.
Yes, no trial.
But you, right, and you understand that you're giving up those rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been handed and has been provided the Pittsfield Township Department of Public Safety report for their case number. It's like 25-15840. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if I accept your plea, if between the time of my acceptance and the time of sentencing, you commit any misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that, sir?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
There are none, Your Honor.
All right. And have I complied with the court rule and would it be proper to accept this defense?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed.
Without objection.
Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
January 14th.
January 14th, 2026, 9 a.m. As your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you.
You have a good holiday, sir.
You do the same.
Can I ask something? If I able to go? Not to him.
Outside.
All right.
Thank you, Your Honor.
Thank you.
And he can stop down at the probation department and be down the hallway on his left.
We've already made arrangements. Thank you, sir.
Thank you. Court does call the case, People versus Brandon Nash.
Ask the to the people.
Oh, boy. Here we go. I don't think we're done.
How are you?
I'm great. Go ahead. Ms. Valdez, did you?
I did.
You did? Okay.
Thanks.
Go ahead.
Yep, I'll do the spiel. My name is Sam Fisk. I'm a student attorney with the Civil Criminal Litigation Clinic at the University of Michigan Law School. I'm seeking permission to practice under MCR 8.120 under the supervision of attorney Sarah Sallin.
Good morning, Ms. Sallin.
Good morning, Judge.
Permission to practice is granted. Aren't you guys done yet?
Almost. Yeah, we have finals next week, so,
Do you?
we do.
How are you going to do?
Somewhere in the middle, and that's all you can hope for.
Somewhere in the middle. Boy, you're an optimistic person, aren't you? Good.
Yeah, there you go.
Your co-counsel is going to get all A's.
Yeah, well, that's why she's not speaking today. She's studying.
Wow. Is that really why? I don't think so. Anyway, all right. What are we doing on this case?
So we submitted plea information yesterday morning, and
Yes.
we're hoping to sort of iron out the terms of the plea.
All right. Where's your client?
Brandon, if you could unmute yourself and state your name for the record.
Brandon Nash.
The plea form indicates that the defendant will be pleading no contest to the charge of retail fraud in the third degree, the 93-day offense. Upon a successful plea to that charge, count one would be dismissed. That is the entirety of the agreement. The sentencing judge waiver is checked, but this is actually my case.
Yes, Your Honor.
That's the court's full understanding. Is that correct, counsel?
We'd also like to add the condition of restitution. We were just trying to figure out.
Pardon?
Restitution will be part of the probation order, I expect, Your Honor, jointly and severally with Mr. Nash's co-defendant.
Right. And counsel, what were you trying to indicate to me about restitution?
Oh, that Brandon, the defendant, will pay the full cost of restitution of $732.95 at the time of sentencing.
Okay, is it, well, that's a little bit different. Is he's gonna pay that full amount at the time of sentencing? Because what the prosecutor's indicating to me, which would typically be the case, is restitution will be part of any sentence that's going to come from probation, or a recommendation coming from probation. And so those are two different things, potentially, anyway.
Your Honor, if I may, and Ms. Feltes might actually my students might know, or Ms. Feltes, I believe there was an offer that if he paid it on sentencing, that she would recommend that I think there would be a recommendation of no time or a case closed. That would be her recommendation.
If he
paid the full
paid it
restitution.
sentencing,
I did, so what I indicated via email, did not put on the form, was that the total amount of restitution, $732.95. If he can make restitution at the time of sentencing, I would leave it in the court's discretion to sentence him only to fines and costs, because he'll be supervised by his parole agent in Kalamazoo. I think the court recalls Mr. Nash is a person that was not in compliance with parole.
yeah.
That's something I was going to indicate to Ms. Pilara later. We can put that on the plea form if the court prefers, but I didn't think it necessary to put on the form.
Well, but it's some agreement that nears to the defendant if he does something.
It does.
Right.
Would the court prefer it on?
I would prefer it on the plea.
If it's okay with defense counsel, I can approach and write that in if it's okay.
That's okay with us. Thank you.
Yes, I can go ahead and start the
Yes.
plea while you do that. Thank you. All right. Mr. Nash, you understand all of that, sir?
Yes, Your Honor.
All right. If you could please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name for the record.
Brandon Nash.
All right. He's pleading to third, right?
Yes.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of retail fraud in the third degree. That is a misdemeanor. Yeah, you've got background noise that you got to turn down, sir. All right. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about a no contest plea I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead no contest?
Yes, Your Honor.
All right. Counsel, the basis for the no contest plea?
Civil liability, Your Honor.
All right. So, Mr. Nash, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You had signed an advice of rights form and went through that with your attorneys. Is that correct, sir?
That's correct, Your Honor.
Do you have any questions regarding any of the rights on that form?
No, Your Honor.
You understand, particularly addressing paragraph 5 being your trial rights, that you're waiving or giving up the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
All right. You understand that your plea in this case could be about, which one are you on? You're on parole, is that correct?
Yes, Your Honor.
All right. You understand that your entry of a plea in this case could be a violation of that parole.
Yes, Your Honor.
You understand that if it is considered a violation of your parole, you could be sent back to do the remainder of your prison term. You understand that, sir?
Yes, Your Honor.
And understanding that, you still wish to enter this plea of no contest.
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-04121. Any objection to the court having reviewed that report?
None from the people, and for the record, Your Honor, I just took a photo with my work phone of the updated plea form and sent it to defense counsel.
All right, very good. Any objection, counsel, to the court reviewing that report?
No objection, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
All right. Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
January 14th.
Do I have a sentencing date before that?
22nd. That's just the date.
Okay, but I may want to do something different on this. Are you guys, see, this is where the professor in me comes out, and I hate it when it does, because then I'm nice to people. Are you guys still around the 22nd of December?
We won't be, Your Honor, but I would actually
You
prefer to
won't
have-
be?
No, we won't be, but we would actually prefer to have the later sentencing date if possible. Brandon actually started a job 2 weeks ago, so he's been saving money for the restitution.
Got it. Okay.
Passing his
Well,
drug tests, all that stuff.
right. Part of the reason I was going to try to do that is I remember the look in your co-counsel's face the first time she heard the word parole, and all heck broke loose at the very beginning of this because it wasn't probably how she viewed it going forth. And I just wanted to try to see if I can give you guys an opportunity to finish it through. But if we can't do that, that's fine. And I understand that he needs the time to do that. So sentencing in this matter will be January 7th, 2026, 9 a.m.
Thank
All
you.
right. Pardon?
January 14th.
January 14th, excuse me. 2026 at 9 a.m. All right. And do I have permission? I do. Mr. Nash, I'll ask you to wait online. If counsel wants to go in, I don't know if you want to go in with him. He's going to get some probation information, and you can at least see how that process works. And go in, and that'll help us start the sentencing process. All right.
Okay, Your Honor.
Thank you,
All
Judge.
right.
Yes, we'll wait
Anything
around.
further? Anything further from either side?
No, Your Honor.
All right, let me say something. I usually, well, I say a lot to student attorneys. But I probably won't see you guys again. But it's been an absolute joy having you practice before me this semester for you guys or during this time. All right. You guys have done a great job, quite frankly. Sort of battling through some things that sort of would have surprised even some veteran attorneys as to how they were going to deal with it. You guys have done a great job. All right. All right.
Thank you, Judge.
Appreciate
Thank
it.
you.
Wish you all of the best and happy holidays to you.
Thank you,
Likewise.
Liana.
Appreciate it.
Thank you. You're going to put all 4 in.
Yep.
Okay.
Good words from Judge Simpson. Good to hear. Welcome, everybody. It is Wednesday. It's the Courtroom Files Live. Glad to have you all here today. It's a choose your own adventure. So there is a hearing going on right now with Judge Middleton that involves following too closely. So this is a traffic thing. And somebody is challenging like $150 ticket. If that interests you, put a 1 in the chat. If you could care less, put a 2 in the chat, and we'll see where that comes out. In the meantime, well, I figure out if that's something you want to see or not. Let's go. We'll stay in Michigan, but we'll go say good morning to Judge Oakley.
Called already. We have pre-tried the matter and reached a resolution.
Yep.
So the driving license suspended second offense will be dismissed. We'll be pleading guilty to allowing unlicensed driver to drive.
Good.
Requesting immediate sentencing if the court will allow.
Okay. Did you discuss your rights and options with Mr. Hadley? You understand all that? You understand the possible penalty to the added charge? Are you pleading guilty to the added charge today? Are you doing so freely and voluntarily? Did you drive, excuse me, did you drive a vehicle in Belleville, August 14, 2024? At that time, was your license suspended, revoked, or denied? I'll accept your plea. I'll dismiss the original charge. What's the status of your license now? How close are you?
Close.
Good.
When do you think you'll have it?
I'm hoping right after the holidays is the first of the year. I have
Okay. Okay. All right.
3 children that.
Good for you.
Oh,
Good for you. Yeah. Yeah. Are you working? Which one have you had the longest?
They're
Okay. Where at?
you know, they're in Belleville, brain injury and spinal cord
Yep.
rehabilitation
Yep.
specialist, and then also clean houses.
Okay. Okay. Okay.
On the 24-hour work cycle. Right?
Yep.
So,
Okay. Good. Anything else you want me to consider before I sentence you? Okay. All right, so Mr. Hadley, do you know that she ended up with 2 civil infractions on the same date? Did you talk about that? All right, then.
Please see if we can find them.
It's no insurance and traffic signal. So I'm gonna lecture you because he would have lectured you if he would have known this.
The vehicle wasn't.
I know, but what happened is you got the tickets and we didn't hear from you. So you owe us $900 just because we didn't hear from you. The no insurance is $498 and the traffic signal is $396. Too old. I'll tell you what I'll do. Can you commit to some kind of a payment plan, some kind of monthly payment? All right. So, Mr. Hadley, have her talk. I don't know. As difficult as the money might be, it might be even tougher for her to come up with some time to do some kind of mix of payments and community service. But that's an option that she can. You understand that?
Yeah.
I don't either. All right, so let's just stick with money, okay? Yeah, if your kids were old, you could take them with you somewhere, but those little kids. All right, so stick with the money. So you get something set up on the 894 that you owe us on those 2. What I'll do on today's file is I'm going to put you on a 12-month non-reporting probation. That means I've got my thumb over you for the next 12 months. I'll suspend fines and costs on today's file. because you got stuck on the $900 because you didn't come in and make arrangements. So stay out of trouble. That means don't drive until you get your license straight, right? So stay out of trouble. That's the 12-month non-reporting. So I'm keeping my eye on you. Take care of the $894 with whatever payment plan you can come up with, and you're done with us. All right, you got all that? You're welcome. Good luck with the adoption. You're welcome. I bet that means Mr. Perkins is next. Come on up, Mr. Perkins. What do you want to, how far out you want to go for your discovery?
This is a 2024 case. 2024 case, that could be a larger non-discovery. I think our issue is to get a date that I can come back.
Yeah.
Sorry, Judge, who
Basically-
is this, please?
This is Bryant Perkins
Thank you.
Jr. So basically, any Wednesday this year, any Tuesday next year.
And give me just one moment, my apologies, my computer's refreshing. I just want to make sure I'm not following the document that I can't do here. Let's. It's a Wednesday. It was. He's back up here, we're back with this court next week on the 10th. I just don't think we'll be able to get turned around by then. We do January 7th, please.
Is it a Tuesday?
No, sorry. These will be-
Tuesdays. We're switching to Tuesdays after 50 some years.
That'll be beginning of the new year. Okay.
Yep.
Tuesday the 6th.
9 o'clock?
Hey, all right. That's
Alrighty.
like you're on
9 a.m.
Tuesday, January 6th, 2026, 9 a.m.
Judge Martin, so I'll get you the notice in just a few minutes.
So you get some Zoom information.
I just spoke to Emily. She said they can't take the plea because they've never screened him yet,
Okay,
even though the prosecutor.
that's fine.
Well,
That's fine. Right. Are we ready on Singh? People versus Singh. We got both attorneys on.
I am here, Your Honor.
Okay, I thought Heather said we had the prosecutor on too. Hey, Joe, tell prosecutor's office I got to have somebody talk to me about Singh.
Did you receive the warrant?
Yeah, I got it, but I can't take the plea because Mr. Singh hasn't done what he needs to do. I'm assuming, Mr. Dabalski, that you don't want to enter the plea without knowing whether or not he's going in sobriety court.
I guess, yes, Your Honor. I guess that's a fair, accurate
All
statement.
right. And we have Mr. Singh with us.
Initially, you're gonna be disappointed that I couldn't do what you wanted me to do, but I think you're very happy with the outcome. I have Mr.
That's fine.
Patton come in.
Mr. Kaplan, I've got Mr. Singh and Mr. Dabalski on Zoom. My understanding is that we've been trying to get Mr. Singh to cooperate with my probation department for months so we can make the determination whether or not he's eligible, and he just won't do the paperwork. Mr. Dabalski, do you have something you might want to add to that? Because that's my understanding.
That is an accurate recitation, Your Honor. He has informed me that he has sent the paperwork to the probation department on at least 2 occasions. I don't know what the problem is.
Well, at this point, I don't want him in my program. So I don't know if he's eligible for our program or not, but he's not a team player, so I don't want him.
Withdraw the offer, Mr. Kowalski.
I'm sorry?
And so I'll have to withdraw the offer of hold by side.
Well, can I see if I can get, he's a resident of Canton and the 35th District Court I see if I can get him in. That's,
I'll give you one more adjournment if you want to see if Ken takes him.
yes, please.
How much time you want for that?
4 weeks.
Heather, give me a January date, would you?
Yep, we have January 6th or 13th,
The 13th.
9:15.
Zoom.
Yep. It'll be
Thank
Judge
you.
Martin, sorry. Yes,
Thank you.
That was the 13th, 9:15.
correct. Judge Martin.
Yeah, I just adjourned the PCC for him to get a chance to talk to 35th.
Thank you.
All right, good luck.
Thank you, Judge. Happy holidays if I don't see you
Same
before.
to you.
Thank you.
All right, we had not a whole lot of voting on the Choose Your Own Adventure, so I'm going to choose for you. We're going to go ahead and go to Judge Middleton and see what's going on with this traffic violation hearing.
And again, I apologize. People will watch me blow my nose all day, but eventually I should live through this. All right, this is a formal hearing in the matter of Jasmine Ray Adair. The charge alleges a violation of MCL 257643 under the Motor Vehicle Code for following too closely. As I indicated, this is a civil infraction. I believe it carries 2 points, and it does carry, I believe, $120 fine. Assistant Prosecuting Attorney Abigail Stoll is here with her Officer Jesse Raymond. The jurat is signed. We're ready to proceed. Madam Prosecutor.
I'll waive opening argument.
Okay, certainly. We don't need any. Are you ready to proceed?
Yes, Your Honor.
Okay, you may call your witness.
I'll call Deputy Raymond to the stand.
Good morning, sir. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief? I do. Thank you. Have a seat. And would you state your name for the record, please?
Deputy Jesse Raymond.
And spell your first and last name.
JESSERAYMOND.
All right, Ms. Stoll.
Deputy Raymond, where are you employed?
St. Joseph County Sheriff's Office.
How long have you worked there?
Just under 6 years.
What do you do?
Primarily now I'm covering complaint vehicle, meaning I take complaints on the road. I also conduct traffic stops.
Do you have any other experience in law enforcement?
Outside of the sheriff's office, no, but I do have other assignments.
Laura, can I get a white pen?
Were you on patrol on July 25th of 2025?
Yes, sir.
What shift?
I was on the day shift. I was assigned to the traffic unit.
What was the general location where you were at?
I was traveling southbound on 131. I was south of Three Rivers. I was just approaching Drummond Road.
All right. Did you see something that caught your attention?
There's moderate traffic that day. I did notice two vehicles that were very close together.
Could you describe the vehicle that was following?
I don't recall.
What did you do after that?
So I had my radar unit activated. I clocked the lead vehicle going approximately 60 miles an hour. I saw the following vehicle was traveling quite close as they passed by. I estimated it to be about a car length behind. I turned around at that intersection and it took me about a half mile to catch up. I caught up to him just before Gleason Road where I conducted a traffic stop.
I'm sorry, forgive me. I'm a little hard of hearing. I didn't catch the tail end of what the witness just stated. And you caught up half a mile at Gleason Road and then you said something else.
That's where I conducted the traffic stop. It was
Okay.
just south of Gleason, northbound.
Thank you.
And then what did you do after that?
I made contact with Miss Adair. I explained the reason for the traffic stop. Got got her license, registration, insurance, and issued a citation.
Is Miss Adair in the courtroom?
Yes, she is.
Could you describe something she's wearing and point her out, please?
She's wearing gold frame glasses and a black shirt.
Let the record reflect that the officers identified the defendant.
It may.
And then did you write Miss Adair a ticket?
Yes, I did.
What for?
For following too closely.
In your experience, was that a reasonable length to keep?
No, I have considerable experience, particularly with traffic crashes where there's rear end collisions. Almost all of those cases, it's a matter of either following too closely or they're unable to stop in a short period of distance.
Objection. I don't think there's a foundation laid for his expertise as being an expert with traffic crashes.
Well, all right, we can establish that. He indicated he'd been an officer 6 years and then traffic enforcement. Madam Prosecutor, would you inquire further about his qualifications in this area?
Deputy Raymond, do you have any sort of special training or experience in traffic accidents?
Just academy training and then routine experience with traffic crashes. I respond to and investigate crashes as a traffic unit, also as a complaint deputy.
How often do you respond to these accidents and complaints?
I would say on a weekly basis over the last 5.5 years.
How many citations do you think you've actually written?
I couldn't give you a number.
Over hundreds? This is a civil infraction, and he's given his opinion regarding this circumstance. I think he's qualified in the context of a traffic enforcement officer, certainly not an accident reconstructionist or anything, but I'll allow the testimony regarding his opinion about why he wrote this citation.
Thank you, Judge.
You said that you were traveling on US 31 southbound?
Objection asked and answered.
We're just getting back into it. Yeah, it's 131. Go ahead.
Where were you located when you stopped the defendant?
We were on US 131 traveling northbound. We were just south of Leeson Road.
In what township?
That's Fabius Township.
In St. Joseph County, Michigan?
Correct.
Thank you. Nothing further.
Morning, Deputy. I'm going to ask you some questions. If anytime during me asking the questions, if you don't understand or it's not clear, feel free to ask me to clarify. Deputy, you testified that you were the one who stopped my client, Miss Adair, correct?
Yes.
Okay, so you recognized her?
Yes.
Okay, but didn't you just testify you didn't know what kind of car she was driving?
Correct.
Okay. Would it help if I showed you the ticket to refresh your recollection?
Yes.
Okay. May I approach, Judge?
Yes.
Or I guess the jurat. Let me know when you're done looking at the ticket. Is your memory refreshed?
I have the citation for a 2012 Toyota. I don't remember the model of the vehicle. I do remember the Indiana registration.
Would you disagree with me if I told you it was a Toyota Prius?
No.
Okay. So when you testified
for the people, you stated that you were going in the opposite direction, right?
Correct.
And you just testified that my client was driving a Toyota. Do you know what the vehicle was that was in front of her?
I don't recall.
Okay. Would you have any reason to doubt me if I said it was a GMC pickup?
No.
Okay, but you did catch the distance between that vehicle and my client?
Correct.
Okay, and you remember that there was one car length?
Correct.
Okay. Did you provide any video recordings to the people? Like body wear cam or dash cam?
I did not. I don't know if my clerks did or not.
Okay, so would it surprise you if it was provided? Okay, and do you recall what you said to Miss Adair when you approached her vehicle?
Yes, I do.
Can you share with me what you said?
Yep. So I asked her for her license, registration, and insurance, which she provided me. I informed her that she was following the vehicle in front of her too closely. I told her that they were traveling close to the speed limit. And given that speed, that was too close to be following the vehicle in front of her.
Would you doubt me if I just stated that you stated at the time that the courts have found that you need to be traveling one car length per 10 miles per hour?
I did say that to her, not as a.
What authority are you relying on for that statement? When I say authority, legal authority.
I was using it as an education piece.
So you just made it up?
No, I did not.
Okay, well, where'd you get it from?
I don't recall.
Okay. So you read this, you're familiar with the statute, right?
So
And what does it use?
you must be no closer than reasonable and prudent to the vehicle.
Reasonable, prudent person. Are you familiar with, you're familiar with the State of Michigan Secretary of State, right? Okay. Are you familiar with a publication that they put out called What Every Driver Must Know?
I'm familiar with it. I don't recall any text in it.
Would you doubt me if I said it doesn't say anything about a car length for every 10 miles? Okay, I'll help you. It doesn't.
Objection, Your Honor, hearsay?
Well, the officer accepted the answer that he accepted that he is familiar with that publication, which every Michigan driver has to review before they take their driver test. I'll allow it. It's not damaging really either way.
As a matter of fact, well, let me back up. Would you doubt me if that publication takes into account what is considered the reasonable distance between two traveling vehicles? Okay, would you doubt me if it says that you need to take into account the vehicles, the drivers, condition of the road, weather conditions? Okay. You interestingly didn't testify to, you talked about moderate traffic, but do you remember the weather conditions that day?
Yep.
Okay, what were they?
It was a clear day, dry roadway.
There was no rain, was there? Mhm. Okay, and do you know that you recall on the side that my client was driving on, how many vehicles were traveling? About the time that you witnessed these two vehicles going down that road, I'm sorry.
Specific number, I don't recall.
If I played the video, would you doubt me that it was just that vehicle and her vehicle? Okay. As a matter of fact, on your side where you were traveling, where you said you witnessed the cars traveling too close to each other, there was a lot more traffic, or as you said, moderate traffic. Would you doubt me? Okay. Did you notice that, or do you strike that? When you came up behind my client, did you notice the, I guess, double lines, dotted lines in the roadway?
At the location of the traffic stop. I believe it would have been a double line, but I don't recall.
You don't know if my client was attempting to pass that vehicle either, do you? You didn't ask her, did you?
I had turned around and followed the vehicle for approximately half a mile.
Okay.
Real quick while he's between questions, because I know you have to leave soon. Barbara, thank you for the 5 gifted memberships and the $5 super chat. I really appreciate you.
I'm gonna inject myself a little bit.
I'm sorry, Judge.
I'm gonna inject myself into this to add some context. On the map, run 131 looks like it runs flat, straight, north and south. Is that correct?
It's a relatively hilly section.
Well, that's what I'm gonna ask. It's actually on what's known as the Big Hill. Is that correct? 131 and Drummond Road is on what's known as the Big Hill between Three Rivers and Constantine. Is that correct?
I'm not familiar with the term.
You're not? Okay. Anyway, it's a big hill and it's common. Well, maybe I'm too old, but there've been many, many accidents there. One time we had 2 drunk drivers hit each other on the big hill and they were both killed. Anyway, was this on the hill?
A portion of the observation period was, yes.
Okay, so this is a big hill. And so they're both going up the hill at that point. Is that correct?
They had gone up the hill and I had stopped them after descending down.
Okay. All right, thanks.
Anything else, Judge? I'm sorry.
No, I don't know if you've been there, but
Unfortunately, I'm not familiar with.
at any rate, it's on the big hill, and apparently we're headed uphill, and then he stopped them as they headed down.
If I played the video of you turning around, well, is your video activated? It's not running all the time, right, Deputy?
It's running, but it only pre-records a certain time frame before it's activated.
Okay, because I was shared, it was shared with me the video, but it wasn't shared of, I guess, where you felt that the car lanes were too close. But I got a video that shows you stopping the vehicle. I don't know if it would help the court making a decision if the people don't object. I mean, I'll play the video.
Well, I was hopeful they would play it.
I'm kind of a little surprised, but they can present their case any way they want.
Yes. Yeah, you can present the video to the officer. We have a way to do it.
I'm not technical. I mean, I could set this up there and you can look at it.
Well, we have a way to play it on the big screen. Although I'm not sure any of us are technically at depth enough to plug it in. It should plug in.
I'll give it a shot. Okay.
Well, let's undo the cord. See, it's Velcroed there to the wall. All right, you should be able to do it from your laptop at your Ms. Davis can do it. I don't know. Josh, have you done it from this?
I think I have a port for this, Judge. I think we might be. Forgive me for what you're about to witness on my desktop. That looks like madness, but there's a method to it. So if it. Is there something that needs to be?
Yes.
While they sort out the tech, I want to point out what Michael just put in the chat. This is one of those times where it's definitely the principle rather than the money. I would agree. This is a $150 ticket that they're fighting over here, ladies and gentlemen, and that's what I find intriguing about this. They're definitely trying to make a point. So let's see where this goes.
I don't know which, it's been so long since we've done this. It shouldn't be such a profound problem. I think it's this big.
And just so I'm making a record here, Your Honor, the video that I have that was shared with me just reflects the stop. I don't think it actually reflects what the deputy testified to what he witnessed when he was coming the other way. So I don't want you to go through all this laborious effort.
All right, so it doesn't show the actual.
It shows him doing a U-turn and coming up behind the two vehicles, my client being the closer one to him. It doesn't show what what Deputy
Raymond
James testified to what he witnessed when he was coming the other way. That's why I asked him about if his camera was activated at that time. If there is footage of that, it wasn't shared with me.
All right. Rather than get lost in the weeds here,
Okay.
we didn't prepare for this.
I'm sorry.
Just go ahead and show it, the video from your laptop.
From the laptop, okay. And prosecutor, do you want to stand in front of this so they can see it?
It's not ideal, but it's no jury. It's a formal hearing. Can you see it? Abigail, maybe you can stand behind it.
Let me make sure the volume's on.
What are we seeing here, officer?
So I believe at this time I had already turned around. I was traveling northbound.
Okay.
Like he said, you can't see in the video the time that they initially passed me due to the latency in the activation of my recording.
So you're going down the hill at this point. Is it alleged that she's following too closely at this point?
Yes.
Yes.
Indiana commemorative Boy George X-ray 233 BGX 233.
Traffic stop. Civil infraction. Traffic violation. US 131/Leeson RT Phineas Township.
So this, you can't, I don't believe you can hear anything. The body work camera, this is just a stop, Judge and Madam Prosecutor. If you want to hear the body wear camera about the car length thing. So this is the stop. This is the video of the body camera.
Yeah, 7526 traffic stop. Indiana commemorative Boy George X-ray 233 BGX 233. Hello, how we doing? Wonderful. Do you have your license registration? Part of the traffic. Chris and I stopped you, you and the vehicle in front of you guys were both going about the speed limit. You were right on his tail, so you gotta have a little bit of space off of him, okay? Rule of thumb, there's not really any number on it specifically. The courts have found that about 1 car length for every 10 miles an hour. So you really should have been 5 or 6 car lengths back behind him at the least. So, okay. You got interest in the vehicle?
Okay. Thank you for indulging me, Judge.
Thank you. That certainly didn't translate very well to the live stream, but they could hear it and I could see the video. I didn't see what was going on the way up the hill, but I could see what was going on the way down the hill. All right. Any further questions for this officer?
No, thank you, though. Thank you, Deputy. Appreciate it.
Ms. Stoll, do you have any further questions for the officer? Do you have any questions for the officer?
No, Your Honor.
All right, thank you. You can step down. Any further witnesses?
No.
All right. Mr. Spinolio, you have any, do you wish to call the defendant?
Judge, if you're prepared to make a decision, and being mindful of the court's docket, if you're prepared, I'll waive presenting my client. I mean, the video speaks for itself. I think that the facts, what the deputy said,
thank you. I'm disappointed in that. The prosecutor didn't play the video. Did you even viewed it? Have you seen it before?
I saw it, Your Honor.
Okay. Well, I would have liked to have seen it as part of the prosecution case because she's right on his tail. The video sunk your boat. You're doing pretty good because they hadn't even looked at the ticket or know what kind of vehicle it was, and his testimony was unclear, and it wasn't clear where it was. It's on the biggest hill in St. Joseph County. But you were right on his tail. I don't know where you were going up the hill, but going down the hill right up until the stop, you were right on his bumper. And it's not a place to pass. Passing is prohibited there for quite some time, going up the hill and down the hill. What the statute actually says, the officer says, the rule of thumb is you should give 1 car length for every 10 miles an hour. That is a quote unquote rule of thumb. We've heard it on television commercials and other thing. It isn't in the statute anywhere. But what the statute says, the officer quoted it pretty well. The driver of a vehicle shall not follow another vehicle more closely than is reasonable and prudent, having due regard for the speed of the vehicles and the traffic upon and the condition of the highway. So this is a 2-lane highway. It's a state highway with a center line on a large hill, and passing is prohibited going up the hill and down the hill. The speed limit there is 55. He testified that he thought the first car, which he couldn't remember what it was, if he looked at the video, maybe he could have discerned it, was going 60. The ticket says she was following lead vehicle 1 car length going 57 miles per hour. This is a civil infraction. You can't go to jail for a civil infraction. And you don't have the right to proof beyond a reasonable doubt. You have a right to proof beyond a preponderance of the evidence, which is a much easier standard for the prosecutor to meet. It means just barely more than the other side. So I was trying to figure this out, but as soon as I saw the video, in my impression, you were too close behind that truck. So I find that you're responsible for following too closely. And I'm gonna fine you $120. You can pay that today, or I'll give you 30 days to pay it if you need it. Or do you want to pay it today, or you want me to give you an envelope to pay it? All right. We don't have enough trials for young officers to learn that they're going to be subjected to cross-examination. And when a competent attorney comes in and asks questions and makes appropriate objections, it's a lot harder than some layperson trying to do the best they can. So the point being, when you come to court, you should review your police report, you should review the ticket, you should review the video. The video should have been presented, but I'm not doing your case. The defendant actually provided it, which gave the court proof beyond a preponderance that she violated the statute, but you can't sleepwalk through these. This defendant came prepared, but I did find a violation. So you can go out to the counter, pay the $120. This will go on your Michigan and eventually Indiana driving record. It's not exactly the crime of the century, but you were too close to the car ahead of you, in my view, after watching the video. All right, we'll be in recess.
Well, that turned out interesting because, to be honest with you, I think we all thought that there was a point that was trying to be made there, and that the defendant probably knew that she was right. But I think it was Wahoo that pointed out that they could also have been trying to avoid points if they already have a bad driving record. But that was a swing and a miss, and probably cost a lot of money for that. So there you go. Let's get out of Michigan. Let's go to Florida. Wade Mercer.
The influence of one count of refusal to submit to a breathalyzer test after a license suspension. Miss Brown, there is probable cause for the charges, ma'am. I think it's based on an old license suspension, or that may be the name of the statute. I see the look on your face. Refusal to submit to breathalyzer is now a criminal charge as of about
July 1st.
As of July 1st. It used to not be a criminal charge, but it is now. So you've got those two charges that you're accused of. I'm going to appoint the public defender's office to represent you, ma'am, and I'm going to ask that you listen to Mr. McDaniel, and he's going to tell us where we stand.
No, we just asked court to consider a cash bond or a conditional release.
Okay. Miss Brown, I noticed a Jackson County address, ma'am. Are you employed?
No, sir.
Okay. Miss Brown, how do you provide for yourself or your family if you're not working?
My children's father, I live with my children's father. My child is disabled and I care for him.
Okay. That's a very good explanation. I appreciate that. How old is your child?
He's 19. He goes to the school behind us, Next Step Academy.
Ma'am, you haven't been charged with a crime in several years. Is that accurate?
Yes, sir.
In fact, the only thing I see is a 2019 charge out of Bay County. Is that the last time you were charged with a crime?
Yes, sir.
Let me see if the attorneys have any additional information before I address your bond or your release. Mr. McDaniel, anything else?
No, nothing else.
Mr. Mitchell?
If she wants to do a cash bond, we have no objection to that.
And I'm going to offer a conditional release with that history. Mr. McDaniel, would she prefer the conditional release or the cash bond?
I think it was according to how much the cash bond was. So
It'd be the normal 10% of what the normal bond I would set for DUI. So the normal bond's $2,500. If you want a cash bond, it'd be $250. I am going to offer you a conditional release. Either way, you're going to have a condition not to possess or consume alcoholic beverages and not to drive a motor vehicle unless you have a valid license. So if you get a valid license, you certainly can drive. But if you get caught driving without a license, that will violate the terms of your bond or your conditional release. And your license may or may not be valid depending upon how the officer did it. I can't tell you without seeing the ticket. He may have given you the right to use that ticket as a license for 10 days. They do have the authority to do that, but it's on the back of the ticket. So it's your choice whether you want to post the cash bond or whether you would like to accept the conditional release. Do you have any questions, Ms. Brown? Actually,
sir,
let
I
me
don't think
clarify.
so.
You have two charges, so your bond will be $250 each. Your cash bond will be $500 because you have two charges, not one, but you will still have the conditional release option. So do you have any questions, ma'am?
No way I could just do the 250?
No, not with two charges and a prior DUI. Now, it's several years old, but you still have one prior DUI.
Yes, sir.
So would you like
Could I
to
make a
post the
call?
cash bond, or would you like to accept the conditional release?
Okay,
You don't have to set the conditional release.
and what do I gotta do for conditional release?
You said a condition was no possession or consumption of alcohol?
Yes. That's the standard on the release, but in this case, it'd be part of the bond too, because of the charge.
Judge, you'll just go ahead and accept the conditional release.
I couldn't hear you, Mr.
Cash
McNally.
bond,
Did you say
two
conditional
cash-
release?
I don't know what to do.
Cash bond, Your Honor.
Okay, so it's a $500 cash bond. I'm gonna ask the jail to give you a notice for your next court date, ma'am. That'll be January the 5th, I believe, at 9 a.m. If we can give her notice for that date, ma'am, and remember, you cannot possess or consume alcohol while this case is pending. We have New Year's between now and then. So just
Yes,
make
sir.
sure you don't get caught drinking, because if you get caught drinking alcohol, that's going to violate your the terms of your bond, ma'am. Okay?
Yes, sir.
All right, ma'am. Have a good day. You'll get to use the phone in a few minutes. The next case we have is Willie White. He's White. Mr. White, good morning. Mr. White, you're here in case 23-96 CT for the charge of violation of probation. Mr. White, it looks like a case where you did everything you were supposed to do, except the probation ended and you still had some financial obligations that you were not able to get done. That's what you're accused of doing. Everything else, just couldn't get everything paid off. But then when at the end came, I guess you kind of, according to the affidavit, kind of disappeared. So I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, and we'll see if we can get this thing resolved today or not. Mr. McDaniel.
Your Honor, I spoke to Mr. White. He's going to be violating his probation, understanding he's going to be sentenced to 30 days in the county jail. He'll have 5 days jail credit. However, he can purge himself out of the jail by paying the sum of $320. He can be released immediately upon that payment at the clerk of court, and that'll resolve this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And Mr. White, did you hear that agreement?
Yes, sir.
Mr. White, that 320 appears to be the exact amount that you owed. We haven't added anything to that other than what you ordered to pay a few years ago. So, Mr. White, is this what you want to do?
Yes, sir.
Any questions at all?
No, sir.
Mr. White, I will accept your admission that you violated the terms and conditions of your probation in case number 23-96 CT. Revoke that probation, Mr. White, sentence you to 30 days in jail. But since it's a financial violation, you'll have the chance to purge and be released immediately and not have to finish serving the sentence. The purge amount is $320. That's your court costs and fines that you have left. Plus, that also includes the cost of supervision you have left. If you pay that $320, you'll be released. You do have 5 days credit. Mr. White, you can pay that $320 at any time as long as the clerk's office is open. Their hours are 8 a.m. to 4:30 p.m. The reason I'm telling you that is if someone shows up at 5 o'clock today or they try to pay it at 5 o'clock, the clerk's office will be closed. You got to spend the night in jail until they can pay it tomorrow. So you're going to use the phone in just a few minutes in the first appearance room or outside the first appearance room. So whoever you call, make sure you tell them that $320 needs to be paid while the clerk's office is open. Once it's paid, the clerk's office will notify the jail that you can be released and the sentence will be over, the case will be over. If you're not able to pay it, you'll finish the sentence, but you can pay it at any time between now and when you finish the sentence, as long as the clerk's office is open. Do you have any questions, sir?
No, sir.
Wish you the best, Mr. White.
Yes, sir. Thank you.
Yes, sir. We have Dylan Arnold next. Mr. Arnold, good morning. Mr. Arnold, you're here because you've been accused of, I believe 8 different felony charges, Mr. Arnold. There is probable cause for these charges. Let me tell you what you've been accused of. 3 counts of possession of controlled substance without a prescription, 1 count of possession of methamphetamine, 1 count of possession of cocaine, 1 count of carrying or displaying a firearm during a felony, 1 count of possession of a short-barreled rifle or gun. That one charge is the only second-degree felony. Everything else is third degree. And the last charge is a burglary of a structure, and that's something that allegedly happened within the last couple of weeks. That's what the warrant was for originally, that led to the other charges at the time of the alleged arrest. So that's a total of 7 third-degree felonies and 1 second-degree felony. Let me check my math here. 7 third-degree felonies and 1 second-degree felony. So, Mr. Arnold, I'm going to set you a bond, but I want to see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
I mean, I don't know if he was using the firearm during the crime. I think he had possessions of them, but that's the only thing. I don't have anything additional.
Yeah. I think the statute, and I went back and read the statute. The statute says use, display, or carries. So since he was outside of a vehicle and allegedly it was in a backpack he had, I figured that was enough for probable cause. Whether or not the state goes forward with that will be their call. But it's not a constructive possession case if he's got a backpack and it's actually in his possession. At least it's arguable. It's a little different than a gun being in the back seat of a vehicle from my perspective. Mr. Mitchell, anything you want to add on that?
Nothing on that. We just request also he be subject to random UAs and have a condition of no possession of firearms.
The random UAs is a standard. The no firearms, I'm not so sure about. Mr. McDaniel, do you want to be heard on this request from the state for no possession of firearms as a condition? He has no prior history as far as I know, and the only gun involvement is allegedly having it. So, Mr. McDaniel, do you want to be heard on that?
Yeah, give me just.
You about to say something, Don?
I guess, Mr. Arnold, he would prefer to be able to possess firearms for his own safety at times, and we leave it up to the court. I mean, he's obviously never been charged with a crime before. Obviously he's got some possession of drugs here. I don't know if, Your Honor, if, possession of drugs is, just because he had a weapon there is equivalent to he shouldn't be able to possess a firearm, at his house or someplace. We just ask the court to take that into consideration.
Thank you. Mr. Mitchell, anything else on that request?
I guess we can modify that since it was a short barreled gun involved, just maybe no possession of short barreled firearms or illegal firearms, obviously.
Yeah, obviously illegal stuff. And I think he's contested that it was, he said he bought that legally and it's a legal lease, but I mean, that's something that would happen at a trial, whether it is or not.
Okay. So, Mr. Arnold, what I'm going to do is set you the normal bonds I would set for these charges. I'm not going to give you a conditional release because of the number of charges that allegedly occurred on different dates. So on the third-degree felonies, which you have 7 of those, your bond is $5,000. On the second-degree felony, your bond's going to be $10,000. That means your total bond is 35 plus 10, which is $45,000 cash or surety. You do have a condition of random urinalysis because of the drug charge, and you've got to put a condition not to possess any illegal firearms. I'm not going to take away all your firearm rights. Now, if you're convicted and you're adjudicated guilty, that's a different story. But if you were using the firearm, that's a difference. That would be a different analysis. But possession of a firearm while in possession of drugs, I'm not convinced that's appropriate at this stage to take away firearm rights. I'm just going to say no illegal firearms. Mr. Arnold, you'll get a chance to use the phone in just a few minutes, sir. It's a cash or surety bond. That means you can go through a bondsman if you wish. Mr. Arnold, do you have any questions? Add one thing. There's no contact with the location of the burglary. That's allegedly a relative's property. I think it was some type of bar or business. No contact with that business that you're accused of burglarizing as a condition of your bond also. Any questions, Mr. Arnold?
No, sir.
All right, sir. I wish you the best. No,
That's
that's
the five.
the one that's got the 10,000 is the possession of short barrel gun. That's a second degree felony. Burglary is a third. At least that particular burglary is. Mr. McDaniel, it's everything I had on my list. Anything else?
All right, that's it for Judge Mercer. I struggle with the whole concept of the quote-unquote illegal firearm. I'm much more of a 2A absolutist on that. I know not everybody agrees with me, but, back in the day, you had people that owned their own warships and cannons and everything else. Yeah, Michael, I have a question. What is an illegal firearm? Exactly. Especially from our perspective, Michael, here in Arizona, where it's practically illegal not to be armed. So, yeah, I don't know. I don't think a firearm should be illegal, whatever its construction. But that's just me, I suppose. Well, maybe Michael as well. Let's go back up to Michigan, where justice is best served in a converted pole barn. This is Judge Mertz.
James Dick on behalf of Mr. Whitmer, Your Honor.
Mr. Whitmer, did you have an adequate opportunity to go through the pre-sentence report with your attorney?
Yes, Your Honor.
Okay. Mr. Dick, are there any additions, deletions, or corrections to that report?
Your Honor, yes, there are a couple corrections that it should be noted. J 284, Your Honor, page 6, under family. Mr. Whitmer's sister, Jennifer LaBeouf, she resides in Philadelphia, not in Michigan.
Okay. Any objection to that change, Mr. Rowland?
No, no, thank you. And under marriage, Jessica Sinandi, she lives in Tennessee, not Michigan.
Any objection to that change?
Not at all, thank you. The last, there's a couple more, my apologies. The employment narrative, the third sentence, he receives Social Security. He does not currently receive any Social Security that's been terminated.
Any objection to that change?
No, Judge.
Okay.
The next page, Your Honor, CFJ 284, page 7, substance use and treatment. The methamphetamine, it was listed as unknown, the start date. It should reflect 2008 as the start date to present.
Any objection to that, Mr. Rowland?
Judge, I have no information to counter that information.
Okay.
And then lastly, the substance abuse treatment. The inpatient at Gaudenzia, the end date was 36 days after the January 1st entry date.
Okay, so February 5th? That sound right?
Yes, sir. Right, yes.
All right, we'll indicate an end date of February 5th. Okay.
No other additions, deletions, or corrections, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor, found them acceptable and accurate.
Thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
I do not, but I thought the defense also had an additional document from Mr. Whitner. I don't know if it provides to the court.
Not yet.
Okay.
But no objection to the court receiving.
Mr. Dick, when you go back, can you move that podium that way?
Yes,
I can't see Mr. Rolla. Thank you. There we go. Perfect.
But other than that, just no additional additions or deletions.
All right, Mr. Rolla, do you have any challenges to the scoring of the guidelines?
No, Judge.
Anything on behalf of the people for allocution today?
Yes, please, thank you. This is the defendant's first felony, however, as is made very clear from the PSI, the defendant traveled all the way from Pennsylvania to Michigan to commit this offense. And unfortunately, the reality of the circumstances, as I understand it, and as indicated in both the police report and the PSI, the defendant is one of many individuals, many of them homeless, that an organization was using multi-state to commit these same type of offenses, not just in Michigan, in many counties, but in other states as well. There's a guideline, a guideline of 0 to 6 up to 5 years with a recommendation of 6 months with 93 days credit. The situation that we were advised of this morning is that the defense is asking for placement in a Lions Den facility. And again, that may be fine. However, the problem that people have with that is it's not a lockdown facility. The people's concern is that the same type of situation that arose to have Mr. Whitmer come all the way from Pennsylvania would still exist, and effectively, because the individuals that are using these people, like Mr. Whitmer, as pawns to do their effectively illegal other crimes, just pick them up all over the place and then take them and commit crimes elsewhere. I don't think that that's an appropriate circumstance. I think at a minimum, even though it's a first felony, there should be some verification that we know where Mr. Whitmer is, because even his own family didn't know where he was because he was a homeless individual. So that's a concern of the people. Thank you.
Mr. Gitt?
Yes, Your Honor. So as Mr. Ellis stated, Mr. Whitmer was used as a pawn in this matter. However, he takes responsibility for his actions of walking in and actually doing what he admitted to do. The history that he has, most of it is all substance abuse related, and that played a factor in him doing what was done during this particular incident. Mr. Whitmer, as it reflects in the PSI, he's not had contact with his children or his wife, who he's separated from for approximately 9 years, because he finds some sort of shame in his substance abuse. And he noted when discussing this with the probation officer that he intended to contact them once he was clean. Now, when this PSI was written, the original tentative date of sentencing would have given him 93 days of credit. I believe that is now roughly 120. So if he were to serve the additional time, even for the 6 months, I believe he would have around a month left of his time in custody. Mr. Whitmer has made affirmative efforts to reach out and be accepted to the Lions Den because he wants to change his life. He knows that he could just sit in jail and do these additional 30 days or whatever it might be, and then perhaps walk away if the court was to adopt the recommendation. But that's not what he wants. He would like to commit to the 8 to 10 month program at the Lions Den to take advantage of the support that they offer, the guidance that they offer, and to help him establish a new life. He's looking for a clean start after this incident is, a clean start in general once he is completed at the Lions Den. If the court would be willing, I think it would be reasonable to allow him to attend the Lions Den as a rehab facility, although he is dried out from his substance abuse after being in custody of the jail for the period he has been. It will help with his reprogramming. It will give him guidance, and he does find hope in God. So with that being said, Your Honor, the Lions Den does report right away if somebody were to leave their facility. Mr. Whitmer, he admittedly has nowhere to go. He's lived in homeless shelters and whatnot for many years, and he hopes to establish some sort of a life and home for himself. And he has expressed to me that he likes Michigan. And it gets him away from what he was dealing with back in Pennsylvania. With that being said, Your Honor, we would ask that the court permits or extends him perhaps a probationary period to allow him to show that he is actually trying to change his life. And court would have the reporting from the Lions Den should any of his circumstances change. That being said, I don't have anything further.
Thank you. Mr. Whitmer, did you have anything you wanted to say today?
I just want to say, I just want to apologize to the court. Sorry, I was in church time at the time. I'm working on my substance abuse, and I've been clean for about 4 months, and I'm feeling great, you know, getting in contact with God. I never like going to church services. You know, I feel very, I'm very, very good about myself. So I want to share.
All right, Mr. Whitmer, I did review the report, so I'm familiar with your background, your circumstances generally, as well as what happened in this particular case. This crime is concerning from our community standpoint, and we have folks coming in from other areas of Michigan or different states specifically to victimize our community. As a court, I have an interest in punishing and deterring that kind of conduct.
Yes.
And so I think a jail sentence is appropriate. You know, based on your record and what happened, I don't think probation is necessarily an unreasonable option, but given your lack of any ties to this community, any individuals that are local that could vouch for you and say, hey, we're going to keep an eye on him and make sure he's doing what he's supposed to do, then I think maybe it would be more appropriate. But in your case, I don't think probation is something that's going to be helpful to the community or to you, frankly. I do think the Lions Den is a great program. A lot of people from my court here, and particularly in Crawford County, participate in that program. They do an excellent job. But Mr. Roll is exactly right, and that's the first thing I thought of when I saw this, which is they don't force you to stay there. So I could let you out. You could go there tomorrow, and Friday you could decide you want to go back to Pennsylvania. And yeah, they'll let me know that you left, but that doesn't do us any good because you're gone. And based on your lack of any ties to the community, based on anybody here local being able to say, yeah, we're going to keep an eye on him, we're going to make sure he stays there and completes this program. I don't have any, and based on what happened in this case, I don't have any confidence that if I were to release you early or have you go there, that you would actually complete that program. And the fact of the matter is, once you've served your jail term, if you really want to do that, you can go right there if you want to.
Yeah, sure.
So I think the recommendation is appropriate. I think it's fair. I think it provides for a degree of punishment and deterrence so that other folks know if they're going to come here to try and commit these kind of crimes, that there's going to be a penalty to pay for that. The court is going to sentence you to 6 months in the Otsego County Jail. I did calculate that credit because this was set for sentencing on November 5th. So yes, I come up with 120 days. Did you?
121 actually, Judge.
121. Okay, 121 days. So 6 months of credit for 121 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, the DNA testing fee of $60, and $68 state cost. You do have the ability to seek an appeal of the sentence, and Mr. Dick, have you provided the Those rights to Mr.
Yes, Your Honor.
You can have him.
All right.
Mr. Whitmer, you're amended request to the count. So we're going to take just a short break while Lancaster's brought into jail.
Okay, so one of the interesting things that stood out to me there, and we see this all the time in court, is when they talk about ties to the local community. And I find this interesting because I talk a lot, especially on the pre-show, about the need to have more things be local because that fosters community, and I think that's one of the things that's missing in Western society right now. But it's also, it's kind of conflicting with where everything is going because everybody looks to the more national level for problem solving and all of that, but yet there's kind of this duality because when it comes to the court, it's all about your local ties, you know? So it's an interesting conflict that we've got going in society right now. Just thought-provoking. Let's go back to Judge Simpson. Young Ronald Reagan is in the building.
All right. Thank you. Calls the case, People versus Desiree Johnson. He snuck in. He didn't need a bell. I found him.
Approaching the podium, and we'll be standing to my right. Please say your name for the record.
Desiree Johnson.
All right. I have before me a plea form indicating that she's going to plead, and I don't have how she's going to plead to the charge. It's going to be a no contest.
Yes, Judge. The court should be in receipt of the police report, and I
I have, and I've read it. It's just the form wasn't checked.
Oh, understood. And I
It
also
indicates that the plea form that she's going to plead no contest to the charge of retail fraud in the third degree, the 93-day offense. Upon her successful plea to that charge, count one, the retail fraud in the second would be dismissed. And did you have an advice or rights?
I do, Judge. You're approaching right now with your
That's the court's full understanding of the agreement. Is that correct, counsel?
Yes, Your Honor.
Yes, Judge.
May I have her sworn?
Raise your solemnly sworn to affirm the testimony you're about to give, truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Desiree Johnson.
Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the third degree. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
Fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Understood?
Yes, sir.
All right. Still wish to plead guilty
Yes, sir.
or plead no contest?
Yes, sir.
Do you understand what a no contest plea is?
Yes. Did you explain to me?
All right. 2 things about a no contest plea I need to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Still wish to plead no contest?
Yes, sir.
Basis?
Potential civil liability.
And to that charge, ma'am, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case 25-11516. Any objection in court having reviewed that report?
No, Your Honor.
No, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, if I accept your plea, if between the time of your plea and the time of your sentencing, you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. Do you understand that, ma'am?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Judge.
And have I complied with the court?
To be more satisfied.
You have, Judge.
Court will accept the defendant's plea to count 2, plea of no contest to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at probation.
Would the court entertain immediate sentencing for the fines and costs given the nature of the charges? It's not
Make
serious.
you happy if I entertained it and then said no?
If it's a waste of time, Judge, we'll decide.
It is a waste of time.
Understood.
But
gotta ask.
Pre-sentence investigation and report is ordered at probation. Sentencing in this matter will be
January 14th.
January 14th, 2026, 9 a.m.
So thank you, Judge.
Bond will continue. Thank you.
Thank you.
Court calls the case of the people versus Masika Willis.
I should tell this for the people.
Carbadell on behalf of Ms. Willis, who is appearing by Zoom. Masika, please unmute yourself and state your name for the record.
Masika Willis.
So, Your Honor, we're here for pretrial. This is a bit of an old case. So, Ms. Willis has a pending felony matter, which will resolve these matters once she's sentenced before Judge Conlon. So we are asking for an adjournment at this time.
When is her sentencing scheduled?
Well, she's currently on warrant status. She needs to turn herself into the Washtenaw County Jail to be arraigned. I tried to submit the warrant recall form, but was instructed to walk herself into the downstairs. So not scheduled yet.
She's got a warrant on this one.
I believe, Judge, I thought this was,
or is this one?
I believe I submitted the online warrant recall, Judge. I believe that was recalled, but if not, I'm asking the court recall the warrant at this time.
Yeah. Was it recalled?
Yeah.
Okay, so it's not marked.
She was on, Your Honor, the reason why.
So, go ahead.
I'm sorry, Judge. Let's say she was previously on warrant status because she was at rehab in inpatient treatment. The facility did not produce her, and then she was in rehab for 5 months at that point, and at this point, she's now living in a domestic violence shelter. So that's why she's not been.
So we don't even know. All right. I'll adjourn this out January 7th, 2026, 9 a.m. Let her get to that and see if they can get everything done before that.
Thank you, Judge. I appreciate it.
Bond in this case. Thank you.
Thank you. We'll be in touch, Masika.
Court calls case People versus Elizabeth Raggett.
Morning, Your Honor. Sam Bernstein with on behalf of Ms. Raggett.
Your name?
Elizabeth Raggett.
We are seeking a resolution with the prosecutor and hoping for more time to do that.
We are close, Your Honor.
Turn the matter out December 17th, 2025, 9 a.m.
Your Honor.
Thank you.
Court calls case People versus Tatiana Tedder.
Good morning again, Your Honor. Sam Bernstein for Ms. Tedder, filling in for Ms. Foster Tucker.
She here? I don't know. Pardon?
Not checked.
Not checked in?
Not checked in.
I think Ms. Foster Tucker and her had been texting this morning, so that's not great.
Tedder? No, I don't have her. Bench warrant will issue for defendant's failure to appear. Bond will be set at $5,000. If you have a 10% privilege on that, that warrant will issue immediately.
No way Ms. Foster Tucker gets a hold of her in a very immediate future. She could hop back on. As I know they've had communication.
She can hop back on. I'm not calling it again. The file's going to be going on.
Okay. If the file doesn't make it down there by the time like I'm down there.
At what point did this look like a negotiation?
Fair enough.
I said, court calls the case. People versus Jeffrey Ostermiller.
People. Good morning, Assistant Public Prosecutor attorney on behalf of Mr. Ostermiller. Mr. Ostermiller, state your name for the record.
Jeffrey Ostermiller.
Thank you, sir.
Your Honor, We are hoping to resolve this case. Mr. Ostermiller has an OWI he's pleading to in the 15th District Court on the 16th. We're asking for a date after that to make sure that sentencing goes well, and then hopefully resolve this one.
Well, but was the resolution related to sentencing on this one, or is it related to the plea?
He's being sentenced on the 16th. I think
Got it.
Is what it is.
Sorry.
I think the plea's been entered, so the 17th should work.
Okay.
Sorry if I misspoke.
No, it's all.
No, it's a, well, you said both, so I got you. Or maybe I assumed something, it doesn't matter. I'll adjourn this matter December 17th, 2025, 9 a.m., or as your invite indicates. Okay, Bond will continue. Thank you, Mr. Austin.
I got to step out of the studio for just a minute. I'm going to leave you with Judge Simpson. I'll be back shortly.
Or Shandelli, Barrett.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Barrett. State your name for the record, Ms. Barrett.
Chandel Barrett.
Okay, there she is. I have before me a plea form that indicates that she's going to be pleading guilty to the charge of retail fraud, 3rd degree, the 93-day offense. Upon her successful plea to that charge, count 2 would be dismissed.
Yes, Your Honor.
That's the court's full understanding. All right. Ma'am, can you please raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name again for the record, please.
Chandel Barrett.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading, guilty to the charge of retail fraud, 3rd degree. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty. I'm sorry. That's my son. He has autism. He just came in the room now. Yes, I plead guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
Yes.
You signed an advice of rights form or had one signed on your behalf?
Yes, Your Honor.
Do you have any question regarding any of those rights?
No, I don't, Your Honor.
All right. You understand that you're waiving or giving up those rights, particularly the rights contained under paragraph 5, your trial rights?
Yes, I understand.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of April 18, 2025, at the location of 7000 East Michigan Avenue, Pittsfield Township, Washington County, State of Michigan, what did you do at the Walmart that makes you think that you're guilty?
Attempted to leave with items that were not purchased.
Okay. You got items, you got to the register and you didn't scan those items. Is that what happened?
Yes.
Pardon?
Yes.
All right. And at the time you did this, the store was open to the public?
Yes.
You didn't have anybody's permission to take this property, did you?
No, Your Honor.
And this property you attempted to take was property that was offered for sale by Walmart?
Yes.
All right. Ma'am, if I accept your plea, you understand that if you commit misconduct between the time of the plea and the time of my sentencing in this case, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that, ma'am?
Yes.
Is counsel aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court?
People are satisfied. Satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Bless you.
No.
Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
January 14th.
January 14th, 2026. 9 a.m. is your invite indicated. Okay, ma'am, I need you to wait online. We're going to put you into a breakout room with our probation intake to begin the sentencing process, all right?
Okay. Thank
All
you.
right, thank you.
Thank you.
Court calls the case, People versus Candace Brooks.
Good morning, Mr. Brooks, state your name for the record.
Good morning, Candace Brooks.
Your Honor, I know we've said before, Your Honor, multiple times, let's keep the one less German. We've been playing phone tag the last couple of weeks, trying to nail down a deal. If you want to take it.
December 17th, 2025, 9 a.m. bond continued. Thank you.
Your Honor.
Court calls the case, People versus Gary Lee Hall. Good morning, Ms. Faith. Gary Hall is not checked in.
I would request. He wasn't in contact with me on Monday. That's when he was released from Clare County on Thanksgiving. He contacted me on Monday, but he advised me that his phone was only able to accept calls if he was in Wi-Fi. And he was granted Zoom permission, but unfortunately, I don't think he ever called back our office when he was back in Wi-Fi to get that information. I was unable to send it to him. So I requested adjournment for the record. That's not an explanation for his failure to appear.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $15,000. I'll give a 10% privilege on that. This warrant will issue immediately.
This is today. I'm just getting some.
Court does call the case, People versus Brandon Davis. Try to get some of them.
Ashley Feltus for the people and the state matters.
That's Brandon Gregory Davis.
Oh, apologies.
It's okay. I guess there are two.
Conrad Solar on behalf of Pittsfield Township. Good morning.
Good morning, sir.
An assistant public defender on behalf of Brandon Davis, who should be present via Zoom. Sir, can you please state your full name for the record?
Brandon Gregory Davis.
All right, that's it. Got it.
Thank you, Your Honor. So I'll be very candid due to, I reached out to the other Brandon Davis. This Brandon Davis and I made contact yesterday late.
How was the other Brandon Davis doing?
Well,
all right, go ahead. No, I just thought I'd ask.
But Mr. Brandon Gregory Davis and I had very limited contact.
Gotcha.
So that being said, there is though an offer that Mr. Silver sent double parking. So I don't know if Mr. Davis would like to do that today, in which the misdemeanor would get dismissed and it would be a $180 fine. But we can also, I would also request an adjournment possibly to discuss that with him.
You understand that, Mr. Davis, or no?
Yeah, that's fine. We can do the $180.
Are you sure? I mean, no. I give you time to talk with your attorney about that. I don't mind adjourning it out if you guys didn't make contact.
Well, there's one complication. That's when I thought there was one Brandon Davis, not two different Brandon Davises that offer was made on. So if he wants to take the benefit of that plea offer, he should take it today. Because next 2 weeks from now, it won't be available.
Oh.
Understood. So you got that, Mr. Davis?
Okay, so here's what I'm going to do. I understand what Mr. Siller's saying. He can take advantage of it today. Miss Brandon Gregory Davis.
Yes.
Here's what I'm going to do. I'm going to pass this matter, give Miss Pate at least an opportunity or somebody from the PD's office to have a phone conversation with you about it, okay, before we do anything or before you make your decision. But we'll be able to handle it today one way or another. Fair enough?
Yeah, that's fair.
Okay, so I'll pass the matter. Court calls case, People versus Carlos Mack. Oh, here we go.
Yes, Your Honor, please for Brandon Bird on behalf of Carlos Mack.
Good morning, this is Paul Quinn of Lawrence County on behalf of Mr. Mack on the license case. I don't have the case number in front of me. I apologize.
The driving while license suspended case, that would be the case ending in 1404.
Thank you.
Your name, sir?
Carlos Mack.
All right. What are we doing?
Respectfully, we need to talk to the prosecutor. If we could get a little bit more time to find out an offer, but I would like to address bond.
I'll adjourn the matter to December 17th, 2025 at 9. Is that, Ms. Parity, you wish to do that also?
Join that request, yes.
All right. So I'll adjourn both cases to the December 17th day. All right. As Savant.
My client failed the test, and that was the reason he got failed. He was drinking while he wasn't supposed to be drinking. Let me just put it like that.
Yes.
And he'd do a little bit of time within the Washington County Jail, and I believe he learned his lesson, Your Honor. He missed Thanksgiving. He has a mother who he helps take care of. It was actually paralyzed on the left side due to the fact that she had a stroke, helps take care of her mother. And he understands that doing those things not only risks his freedom, but it affects the people around him. 41 years old, Your Honor, he's a lifelong resident. And also suffering from a physical condition, a hernia, in which he needs to get taken care of. But the biggest thing is, I understand that might be possibly be done in the Wayne County Jail. The biggest thing is that my client learned his lesson, Your Honor. He learned his lesson. First of all, the Washington County Jail is one place he doesn't want to be, and hopefully is one place that nobody wants to be. But him not being able to stand up and take care of his responsibilities and be with his family affected him enough where I believe that he wouldn't commit the same mistake again. Or we can't even call it a mistake. He won't violate bond again.
My problem is how do I stop him from doing it?
Your Honor, we could put on a sober link to ensure that
that's what he violated on.
We could put it on again. We're coming at the mercy.
So
we're coming at
why would I just continue to do the same thing?
Because he just sat in the Washington County Jail, and you're understanding judges like yourself, Your Honor. Respectfully, I understand you understand the conditions of being in the Washington County Jail.
Oh, it's a beautiful jail. Comparatively.
Yeah, when you're on the outside.
No. How you know? Not on the inside.
I just go back there to talk to the client sometimes.
He picked up a case.
I go back down there. No. But Your Honor, respectfully, we're begging the mercy of this court.
I understand what you're doing. I also understand. Here from Rio at the moment, he's what, a 177, and then when he violates, he's almost he's a 0.08, almost a 0.09 when he violates. And then more importantly in that, doesn't retest. So
one thing about it is, after not doing that, he walked himself in here, knowing the fact that there was a potential that he was gonna get arrested. He walked himself in here to deal with the consequences of his actions. And after dealing with the consequences of his actions, I believe that he has a thorough understanding of what could really happen. He lost his job. He lost his job due to this. He lost the fact that he can't take care of his mother due to this. He lost his Thanksgiving due to this. And he lost his freedom for almost 2 weeks, Your Honor. It's about a week and a half. 2 weeks. He lost his freedom. He lost his freedom for 2 weeks. That gives anybody a chance to think about their decisions and the decisions that they make. He made some very bad decisions. We're not trying to get around that fact.
And counsel, I understand that, but what I'm getting at is he comes in here with a case where he's a 177, I think it's DEC, and then he gets a PR, he's released. The major condition, because it's a drinking and driving case, is that he not drink, and then he does.
It's no excuse. It's no excuse that I could, it's no excuse that I could give you for that, Your Honor. There's no excuse that my client's trying to give you for that. There's no excuse that my client's trying to give you for that. And he's not trying to make excuses. The fact of the matter about it, moving forward with this, I understand the predicament that you're in and what you're trying to ask of me and what you're trying to ask of him. How can I ensure that he won't drink when I already gave him the opportunity and he had a sober link on? So that was the least restrictive means of.
Let me put it to you, Mark. If he goes out and I release him, he drinks again, gets behind the wheel and hurts or kills somebody, what do you want me to say to him?
I don't think there's anything that we'll be able to say besides remand.
And I'm not going to be in that position for the people.
He has a 2010 prior OWI as well, Your Honor. It might be an OWVI, but I remember looking at his record. It was a .177, not charged as a high VAC due to my office recognizing the percentage differentials that happen when blood is tested by the Michigan State Police Lab. However, if the court were to entertain release at any time, people would request a scram tether.
And that's 15 years ago, Your Honor. That's 15 years ago.
The behavior hasn't ceased.
We can't,
I'm not holding that against him necessarily, but the behavior has been repeated.
Right.
So what, I gotta wait for the third time, then you want me to do something?
No, I'm not saying that. I'm saying that no driving, no driving condition in his bond. Put back on the scram tether. This is the longest that he's ever spent in jail. This is the longest that he ever spent in jail. And he didn't have the same problems back then that he had now. We're dealing with having somebody that's dependent on him. I greatly understand your concern. I do. And like I said, I can't guarantee anything. I can't guarantee anything, but I know one thing. After speaking with my client, I spent some time speaking with him in the Washington County Jail. And more than just to get out of jail, my client wants to show this court that he could abide by the conditions of bond and be a better person. And that's one reason why we're
he had that opportunity.
He did have that opportunity and he messed it up.
Big time.
He messed it up big time. And he did 2 weeks for it. He lost his job for it. He suffered multiple consequences because of his actions in that matter. And he understands that he can't suffer those consequences anymore. It's too much on the line, it's too much dependent on him. And it's too much dependent on him. And if he does take that risk, then he's at risk of losing more than these 2 weeks.
Here's what I'm going to do. I'm not at this point going to change the bond. This bond will continue. And I adjourn this out to the 17th. Sometime between now and then, I may look at this again and reconsider my decision. But at this point, I'm not reconsidering.
Gotcha.
He put himself here. I didn't. He did it all. I've given the opportunity, and I don't know how many opportunities, and I am not going to be trying to explain to some parent why the child is dead because he got behind the wheel. Not going to do it.
Well, I appreciate you for hearing me out. I do, Your Honor. And there's one thing that I do want to mention. It's not to change your opinion right now today. But my client, it's just something to keep on your mind. My client did say he's been on the pad that they're giving him, working. What was the class?
Recovery.
Working with the recovery while he's been in Washington. So he has taken some steps forward. But thank you. See you the 17th, and I appreciate you for hearing us out.
Not a problem. Thank you.
Thank you. You, Honorable Court, have a great day.
You do the same. Court calls the case, People versus Brandon Davis.
All right, let's change it up a little bit. We still need our 9 to 11 rather percent more, Judge Boyd. So let's go there.
2025 CR 008298, State versus Jonathan Gadina. Can I have parties announce?
Rick Pena for the state of Texas. David A. Garcia, attorney for Jonathan Godina, Your Honor.
And are you Mr. Godina?
Yes, Your Honor.
Am I pronouncing that correctly? Yes. All right. Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Godina, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding on the lesser included misdemeanor offense of indecent assault.
Any objections?
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, the state is proceeding on the lesser included offense of indecent assault as a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes, Your Honor.
Just one moment. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, and he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, and he is.
Mr. Godina, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed under indecent assault at 365 days. There's a $1,500 fine. There are no applications, and there's to be no contact with the complainant. Did you understand that to be your plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial? Sorry, did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
They've been filed but not heard, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. This time, state all evidence. It's exhibit 1 of all attachments.
We've reviewed states 1 and all attachments, Your Honor. We have no objections.
All right. And state, have you spoken with the complainant?
Yes, we have, Your Honor.
And are they aware of this?
They are.
All right. In an agreement?
Yes.
All right. Thank you. All right. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consent to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
All right. And I wanted to let you know, the reason why I wanted to know whether or not the complainant was in agreement with this, because after reviewing the stipulations, I was inclined not to accept this agreement.
Yes, sir.
All right. The court will sentence you to 365 days in the Bexar County Jail, give you credit for any time served. There's a $1,500 fine, and there's to be no contact with the complainant.
Judge, we'd ask that money and time to run current.
I will not do that in this case. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. I look at the stipulations, I go by what the stipulations, right, are presented to me. So in this case, what's in the stipulations are what you stipulated to. You're saying that those are true.
Judge, we pled no contest.
But you pled no contest, but you all didn't.
We pled no contest to the charge of indecent assault, Judge.
No, I'm saying you pled no contest, but it says here that it says here that the defendant and they both style and number calls who being by me duly sworn acknowledge that he read or had read to him the foregoing waiver, consent to stipulation of testimony and stipulations. So if your intent was to do a no contest plea throughout, then you should put the no contest part there as well. So would you like to do that?
Yes.
So in the stipulations, do you have any daughters?
No, ma'am.
All right. So do you have any sisters?
Yes, Your Honor.
And obviously you have a mom.
Yes, Your Honor.
How would you feel if this were to happen to one of them? So it's at the top where you say, you see where you wrote, do not contest.
The documents are
and then
not contested.
And then right at the top, it says contest. Let me point it out to you. And just put there, not contested. All right, is there anything else? If not, you're excused.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
All right, let's change things up. Let's go to Louisiana because there's a hearing that's going to take place and there's a lot of people. So I'm curious. Let's see where this goes.
Please introduce yourself for the record.
Yes, ma'am. Good morning. I'm Darrell Vanoa. I'm the warden.
Ashley Olivo, Deputy Warden.
Reginald Admiral, classification.
Carmen Shipley, vendor records.
Jody Sturgeon, program consultant.
That's it.
All right, thank you. And
Thank
we
you.
have Mr. Williams before us. Mr. Williams, would you introduce yourself? Tell us your name and DOC number, please.
Yes, ma'am. Good morning. My name is Milton Williams. My DOC is 348231.
All right, and you have counsel with you this morning. Counsel, would you introduce yourself?
Good morning, Board. Adrienne Hutchison, attorney for the Louisiana Parole Project, here on behalf of Mr. Milton Williams.
Thank you. And so, Mr. Williams, let me just read the information into the record and we'll get started. So you are currently serving a 99-year sentence for a second-degree murder conviction in Orleans Parish. Your sentence was originally a life sentence. However, it was commuted December 7th, 2022 to the 99 years with parole eligibility. So your parole eligibility date was determined to be December 7th, 2022. And that's why we're here today. Is that information correct?
Yes, ma'am.
All right, your case this morning has been assigned to Mr. Prater, so I'm going to turn it over to him, sir.
Good morning, sir. How are you?
Good morning, Mr. Prater.
What I'd like to do to start with is for you to tell us exactly what you did to get you there, what you've done since you've been there to make us convinced that you're rehabilitated and truly a different person. We hear that a lot. I'm not the same person I was. I want you to convince me you're not the same person you were.
Yes, sir. October 21st, 1993. I was at home. We were having some tile work done in Milton Jr.'s bathroom by a man named Fred. My wife, Mrs. Karen Denise Sturgis Williams, and I ran a small plumbing business. I got a call from one of the regular customers. I checked with my wife and I told her that I had a call to go out to do a plumbing job, and did she want me to ask Mr. Fred to leave or let him finish doing the ceramic tile. She said it was okay. Go ahead and do the plumbing job. I went out and I went and picked up my helper. My helper and I went on a plumbing job. We did the job. And on the way back, we decided to stop and get a few drinks. So we did a little drinking. And before I knew it, it was around 9 or 9:30 at night. I headed home. I dropped him off first, and I headed home. And when I got home, my wife was fussing about me being drunk. Went on a plumbing job and stayed out and get drunk. So I was trying to build a case on her by having the plumbing guys, the tile guy still there. And I started telling her, what this guy doing in my house at 10 o'clock at night? But really, I didn't suspect nothing. I was just trying to stop her from fussing at me by building a case on her. So I walked around her, and she still, Fred, at this time, Mr. Fred left. And I walked around her, and she still was fussing. I went up the stairs, and I went in the bedroom, and she was still following behind me, fussing. I took off my clothes, was preparing to go and take a shower. She would not let me go in the shower. She was constantly telling me about myself. And I knew she was right, because she had told me so many times about my alcohol problem. And I just didn't, I wanted her to stop, because what she was saying was right. And the gun was on a nightstand. I picked up the gun, waving it around, trying to scare her. And evidently, my finger hit the trigger, and I pulled the trigger and shot my wife. And when that happened, I dropped the gun and I ran to my wife to see, but she was not responsive. So what I did was I grabbed the phone and I called my mother-in-law, and I told her what happened. And then when I hung up from her, I called 911. And I talked to them on the phone for a while, and my son came in the room and asked me what happened. And I told him I had the gun in my hand, and the gun went off by mistake. And I turned my wife on her back, and I started doing chest impressions, because I had CPR training. I was doing chest impressions. She started breathing, and I checked for a pulse. And when I checked for the pulse, she had a slight pulse. So I turned on her side, and by this time, the police was at the door downstairs. So I ran downstairs and opened the door, and the police came in, and I led them upstairs to where my wife was at. Then they brought me downstairs and read me my rights. And then the EMTs came, and they went upstairs, and by this time, the police took me and brought me to the police station and arrested me for second-degree murder. I went to trial, got convicted, and sent to prison. While in prison, I thought about what I had done, and I did an evaluation on myself. I took inventory to see what's going on in my life. I realized that my life had become unmanageable. So I finally admitted that I was powerless over alcohol and mind-altering substance. So I took advantage of the opportunities that the Louisiana Penitentiary have to offer for its education, therapeutic classes, such as Alcohol Anonymous, Living in Balance 1 and 2, Substance Abuse, Anger Management, Victim Awareness, Thinking for a Change, and several other classes. Over the years, because of the education and the training and the factual knowledge, I learned to use rational thinking to make better choices in life, to overcome my addiction, to build healthy relationships, and live a pro-social lifestyle. Now, I realize education, training, and factual knowledge won't guarantee excellence, but excellence is impossible without it. I learned through Alcohol Anonymous that being addicted to alcohol and mind-altering substance is a disease, an incurable disease, but it can be treated. Perhaps the most impressive example, the courageous transformation achieved by millions of members of Alcohol Anonymous. At my last parole hearing, I was admonished to take Thinking for a Change, Victim Awareness. I took Thinking for a Change, and in Thinking for a Change, I learned to pay attention to my thinking, realize the risks, and use new thinking. In the STAR program, I learned that your thoughts turn to feelings, and your feelings will determine your behavior. In victim awareness, I learned empathy. I learned that the victim family have rights. I learned that the victim family deserve the utmost respect. Not only is the primary victim, the secondary victims as well, even the unborn children. I was given an opportunity at a reentry program to be a lead mentor. When I came to this prison, I came here a licensed plumber. I worked in every camp as a plumber. I even did the VIP section in the rodeo arena. In every phase of plumbing I've worked. And in 2013, when I finished New Orleans Baptist Theological Seminary with an associate's and a bachelor's degree, I was offered the job as a lead mentor in the reentry program. I was given the golden opportunity to learn how to deal with so many personalities and to be the father that I should have been to my children. And I have over 50 or 60 graduates that came out of my class from all across the state of Louisiana. I've taught the plumbing trade to Angola students, Felt students, and many reentry students to help cut down on the recidivism rate. I even taught life skills, not just plumbing, but I taught life skills, and I told them my story so that they won't have the same problem that I had. I told them the dangers of alcohol. I told them the good about getting a trade and how they could make their family happy, their children, their wife, their mother, and try to avoid coming back to prison. I've taken.
Mr. Williams, let's hold your thoughts right there, and let's move on to the board, and then we'll come back to you before this is over with. If that's okay with you. A person can only listen for so long and retain what's been said, and you got a very interesting story, and I don't think I've ever heard an interview any better, anybody better prepared than yourself. And
Thank you, sir.
Let's pause it right there, and if that's okay with you, Ms. Hutchinson, and then we'll move on. Warden, what about this fella?
Well, you know, as you said, Milton spoke very well for himself, and how he spoke to you today is how he carries himself every day here. He went through everything that he's achieved since he's been here, and that's correct. He did leave out that he was honorably discharged from the Navy in '74. And that's about the only thing that he left out that's on my list. But he, you know, he's a model guy. He's a trustee. He's a lead mentor. He does exactly what he told y'all that he does every day. He's a model president.
Okay. Well, I trust you and I respect that word from you. We'll take that into consideration also. Okay, Mr. Williams, what we'd like to do now is hear from some of your supporters, and then we want to hear from, we've got a few people that may want to speak in opposition to this request, and then we'll come back to you and ask some questions and let you finish up your response to what you had to say. And so, having said that, let's move on to Ms. Hutchinson. We'll save you till last, if that's okay, of the supporters. And Andrew Hunley, would you start us off, please, sir?
Yes, sir. Andrew Hunley, representing Louisiana Parole Project, here to confirm to the board that Milton is a client of our organization, and should the board grant him parole release, that our organization is prepared to accept him into our reentry program. As the board's aware, this is Milton's second parole hearing. We stood by him during his previous hearing, and for many of the reasons that Milton described, that his attorney will describe, our organization has great confidence in his ability to be successful if he's given an opportunity at release, and we base that on his institutional record. He obviously has an excellent disciplinary record, an excellent work record, and he's gone above and beyond with the reentry program and training many young men to become plumbers who have gone home and have had successful careers. I know the board oftentimes tasked at figuring out if individuals, if they're granted parole, can they abide by the conditions? What I would point out to the board was after denial, Middleton did exactly what the board asked him to do. He took the programming that was expected of him. He didn't quit being a mentor or give up. He's continued to do what he's done over the last few decades. He's an exceptional parole candidate as far as our is concerned. We have great confidence that he would be able to follow all recommendations and requirements, and that's based on what we see that he does day to day in prison and what he's done since his last parole hearing. If he is granted release, we have great confidence that we're going to be able to help him with employment. Although Mr. Wilson's, in his 70s, he is in good health and employable, and he's great skilled, and his trade is one that is often highly sought after. So we have great confidence we'll be able to connect him to employment. We would let the board know that we've expressed to him that we would like him to remain in housing with us through phases 1 and 2 of our program before he moves on to his long-term address. But just in summation, we have great confidence in his ability to be successful in our organization. I know you have letters from our organization, from our social work team, who's done an assessment and are prepared to help him enact a sobriety plan upon release, and also our employment program, who's prepared to assist him with employment. We have already invested a lot of time and are ready to invest all the resources our organization has to offer to ensure Middleton's long-term success. And I stand by to answer any questions you may have about his reentry plan. Thank you.
Okay, thank you, sir. We appreciate the work that your organization does, and we appreciate those words. Now, Mr. Williams, we'll hear from your daughter first, and then we'll move on to your granddaughter. So, Carol Webster, the daughter, and she is at LSP. Would you talk to us, please?
Hi, how you doing? I'm Carol Webster.
Hey.
I want to start off by saying that I go to Bible class, and in my Bible class, they teach us forgiveness. And in forgiveness, we want to release somebody from something that they did and understand that they don't really have control over everything. And I do understand that we have somewhat control because we're in these vessels, but God has dictated how things are going to go no matter what. It's in the Bible, and it's said that at the end of times, things are going to go a certain way. We can't escape some of those things. We can't. I'm going to secondly say that my dad was a good dad. He was a good dad. I can't give him no shakes on that. He taught us many things. How to be responsible. We work, we have jobs, we take care of ourselves, we socialize with each other, we keep in good positive conduct so where we don't get in any trouble. Now, we all as kids had problems, but we've learned that you can make a mistake, you can get another chance. My mom was a very forgiving person. She taught us about forgiveness, and she also believed highly in second chances. And they were in love. They loved each other. I saw lots of that. We grew up with a lot of love. I can't say nothing negative about that because I learned how to love growing up with experimenting, but I always had a solid thing to look back on, some solid stuff of what you're not supposed to do, what you can do, things like that as well. I feel like he should get out. I feel like God is in control of this. I'm going to say that again. And I forgive him. And I could speak for all the siblings. We forgive him. And we don't have a problem with him being out. We actually need a father figure in our lives. We need
Okay.
that. Our children and the grandchildren are also missing out, you know?
Yes, ma'am, I understand. Okay, let's move on to the granddaughter.
Actually, excuse me, our third speaker was Mr. Mead. I'm not sure. We didn't have did you?
I've got KNIA.
No, I ain't gonna have no granddaughter that's gonna speak.
Well,
I think they're just,
Not a
this is
granddaughter.
a big day for you, isn't it? No, I'm just kidding.
they're just watching and support. Mr. Mead is the third speaker.
Okay, KNIA Williams, is that who you're talking about?
Yes, they're just here in support watching. We have Mr. Mead present who is gonna speak, the third speaker for support.
Okay, let's hear that then. And I'm sorry. I'm sorry.
No problem.
Dr. Mead.
Dr. Mead, I'm sorry.
That's all right. I'm grateful for this opportunity to speak for Mr. Williams. My name is Dr. Patrick Mead. I'm the senior pastor for our Safe Harbor Church. We have about 80 men in this facility, and so we're down here to visit them frequently. I'm also a former psychologist who went on to become a neuroscientist, and I train federal law enforcement agencies in this country, Canada, and also in Europe. So I've got a lot of experience talking to both sides of the wire. I'm not in the habit of speaking for incarcerated individuals. In fact, in my 68 years, this is the first time I've come to a hearing on behalf of a prisoner. And I've made this exception because I believe that Mr. Williams is exceptional in every single way. I've known him for 4 years now. And some of our members who have known him for much longer, one of them said recently, he is the most rehabilitated man I have ever known. And I concur with that assessment. I read his packet. I've visited with him. He has taken every step, every course, every opportunity to become a new person, a better man in his time here in a penitentiary. And that leads me to the reason really why I felt motivated to come and speak for this man. People need the promise of hope, the possibility of redemption. We're wired that way. When our hearts are changed and when our minds have been cleansed, we seek ways to become free of who we used to be. We search for a renewal. I see that in Middleton. If we rob a man of his ability to be redeemed and renewed, we not only kill his spirit, we kill the spirits of others who have witnessed him do these ceaseless efforts. See the fundamental changes that he made with great determination and effort go for naught. I don't want us to see him dismissed, his prayers, the countless hours in counseling, the 12-step programs. He's moved from being a man out of control and addicted to a man sober, clear-minded, and a spiritual leader among his men. I do understand the need to punish people for the wrong they've done. Mr. Williams has been punished for decades. I know the pain caused by taking a human life lives on in the family and community forever. I know that personally, and I know that that must be true here. But the community also needs faith, hope, and love. Those three things that St. Paul said are all that remain. And if they're taken from us, what kind of people will we become? These are not questions I'm asking you as much as I ask myself when I see this situation. Mr. Williams is not the man who committed this crime anymore. He's a thoroughly changed individual. Every cell in his body has been replaced many times, but more important, he is a new man spiritually. He's become a leader. I will call him a noble man, a spiritual guide, and he's a trustworthy friend. He is welcome in my home. He is welcome in my life. He has a church behind him as well as many of his family. He has friends to make sure he has a soft landing on the other side of this wire. So in conclusion, I know of nothing more a human can do. And what I'm asking you to do, and I know your job is difficult, but I'm asking you to recognize the reality of the new Milton Williams and restore to him and to those who are watching the outcome of this proceeding, the possibility of redemption, of faith, hope, and love. That's my request and prayer, and I'm
Yes, sir.
very grateful for this opportunity. Thank you.
Appreciate that. Excuse me, I got a throat problem. Ms. Hutchinson, would you talk to us, please?
Thank you, board. I got a little throat problem too, so I think what we see here today in his hearing, as well as his previous parole hearing, his clemency hearing, warden's comments over time, the consistency we see is that Milton has spent decades pouring into others. In my brief I've submitted, you'll see evaluation letters from students that talk about him turning his plumbing class into a life skills class. One student saying that, he makes, he wants us to be successful working and family men. He teaches me to be the skills that I need to be a better father, son, and man in society. Milton wanted to add character, integrity, and respect into his class because these were young men whose sentences won't require them to be incarcerated for the rest of their life. So they still had a chance. And he didn't want them to make the grave mistake that he made. But at his last parole hearing, the board asked Milton to do some specific things. They asked him to now pour into himself. They asked him to focus on his crime, his victims, and the elements present in his life at the time, and address those factors in the downward spiral that he had been leading at that time. And so you'll see in my brief on page 10, I go through all the classes that he has taken since that hearing. We've had 12 classes, STR, long-term substance abuse, Thinking for a Change, the RDAP, so the Residential Drug Abuse Program, and the Bible study class, as well as victim accountability letter training. So he has done everything that the board had asked him to do for himself, to work on himself. He had known once he got in that there was a diagnosis for PTSD and alcohol use disorder from his military service time. But taking these classes helped him confront the thinking that accompanied those diseases, right? And so criminal and addictive thinking forced Milton to confront the ways that he justified his thinking throughout that time period, believing that the provider gave him the kind of permission to behave in that way. And believing at that time that he had control over his alcohol use, which he's admitted before you today, he knew he didn't. He knows now that he didn't. So he has confronted the abuse over the family, the manipulation, the intimidation that went on during that time. In the victim accountability letter training, I think he was able to get the tools needed to speak to the loss that was felt across the board by the family. He did Thinking for a Change. I believe he spoke to you all about having to slow down those thinking patterns and recognize and lead with respect and integrity, things he had already kind of put into his classroom, but just with a better understanding. You've seen from us his comprehensive reentry plan with support from LPP, but also you see present the support of all his children. And I want to say, I do truly appreciate his children remembering the good times, but if you have a conversation with Milton, he is more than willing to acknowledge the hard times and the times that he wasn't the best father and husband and friend. But that he has this forgiveness that is not often given to somebody. And I ask the board to look at that type of motivation for a person to maintain change. When you have the forgiveness of your children. Lastly, and this is just because it was not in the brief, I have spoke to Mr. Williams. You all are aware that STR or LPP at any time can deem if he needs any type of alcohol blockers post-release. He is 100% willing to go with those recommendations, and we know STR has done it before. So because he would kind of have dual support from STR and LPP, there is that extra layer of support for his alcohol use disorder. So we just ask that you look at the total package of the work done before and everything that he has done post the last parole hearing. and offer him a second chance with any conditions the board deems necessary. Thank you.
Thank you, ma'am. We'll move on to those in opposition, and the first will be Miss Linda Smith, and she's here. Gee.
I want to say that, first off, I forgive Middleton for taking my sister's life. I forgave him a long time. I couldn't live in peace and not forgive. On October the 21st of 1993, he took away from me what I can never, ever get back. And I'm hearing all the wonderful things that he's done, that he's doing. My sister could never do those things. She loved her husband. She loved her children. She was a very cheerful, happy-go-lucky person. I left home in 1975. My husband was in the Air Force and we traveled. I miss my sister every day. When we talk about our plans whenever my husband retired from the military, getting together again, doing things that sisters do, and seeing sisters happy, enjoying each other. I longed for her. And to come back close enough, didn't go back to New Orleans, but we were in Texas, close enough where I can visit. But whenever I go home, I really couldn't see my sister. There were times, I remember when we were going overseas, she begged me, Linda, don't go. I really want you to stay here, you know. She thought it would be the last time that we saw each other again. That was 1983. It broke my heart to actually leave her. But before I left, I tried to see her. And I knew that she wanted to see me. She said, don't leave until you see me. My husband came back to get us, for us to travel overseas. We went to the house the night before to try to see her. Nobody would answer the door, but you could hear the children in the background. The dogs were let out in the yard. My husband told me to go get in the car. He stayed at the door to knock. Finally, Milton came to the door. He let us in. My sister was in bed. Covers pulled up over her head. She would not pull the covers down. He beat her up. That night. I hear all the wonderful 30 years
but she endured more than 10 years of violence. More than 10 years of violence. Through pregnancy, and it sometimes it seemed it didn't matter what she did. There was still violence. We prayed last hearing. I've been praying every day since I heard about this hearing. My prayer was not, Lord, don't let him get out. My prayer was not, Lord, let him get out. My prayer was, Lord, let thy will be done. Let your will be done. You know his heart. I know my hurt. I know my pain. And my hurt and pain has not eased over the years when I think about her. She was 42 years old. And she will forever be 42. I can't get back what's taken. He can get out and he can enjoy a life, a good life. But I can't get back what I had. I watched and I heard the pain of my mother during that time. I remember the nights coming home from work. I had a little peace when I was at work. I didn't have to think about the loss. I didn't have to think about what he'd done to her. But the minute I pulled in my driveway, the depression just weighed me down. I couldn't sleep. Every time I closed my eyes at night, all I could see was the vision of him pointing that gun at her and her falling. And then I would get maybe an hour or two of sleep and then have to go to work the next day. Over the years, since her death, my address has remained the same. My phone number has remained the same. We never heard a word, I'm sorry. I didn't mean to do it. But as far as not meaning to do it, I feel if you're gonna pick up a gun, you intend to use it. And you intend to inflict harm. So like I said, I forgave him because that's what God expects of me as a Christian woman. But thy will be done. Thy will be done.
Yes, ma'am. Okay. Thank you, Madam Chairman, would you?
Yeah, Ms. Smith, just wanted to clarify something, and thank you so much for your comments this morning. It's very meaningful. He's not allowed by law to contact any of you. That's why you have to. Just so you know.
The comment was really regarding during the last hearing, we were asked if, and it was addressed to him, had he written a victim's statement? Never.
Yeah, there's a program called Victim Accountability Letter, and he can, and I don't know if he's written one or not, but
Okay.
you can, if you file to ask.
Now, to me, if it's intended to give, then it should be.
Yeah, we can't give it to you. He can't give it to you.
Okay, let's move on then.
I think Warden had something to say.
Oh, I'm sorry.
Warden Benoit?
Yes, ma'am, he did write that letter.
Okay, we'll let him know. Thank you.
Thank you, Warden. Okay, let's listen to Miss Sheila Craig, another sister.
Good morning. Morning. I'm the big girl. And I want to start by when I share by sharing some pictures because I want to humanize my sister. This is my sister. This is my oldest sister. I want you to see her face. And when you look at that smile, that's who she was. She was a person that when she showed up, there was sunshine and blue skies. Beautiful inside out. This is her. I want to also make a few comments. One, the day my sister was murdered by Middleton, I was on the phone with her. Sometimes I would call her before I got off from work. And I used to work for the state of Louisiana. And I would call her towards the end of the day and we'd have a conversation. But this particular day, and it was before 5 o'clock, she and I were talking and she was telling me about the gentleman who was laying the tile and that Middleton was angry. But she said she was also angry because the man purchased a cheaper tile than what they paid him for. So she was upset with this gentleman and arguing with him about the tile he purchased and was laying down that wasn't what they paid for. While we were on the phone in the conversation, Middleton Sr. came home. It wasn't 9 o'clock. It wasn't 10 o'clock. It was around 4:30, 5 o'clock. And Middleton Jr. was in the house. And the reason I know that was because they started arguing immediately while she was on the phone with me. And she said, Sheila, I have to go. Middleton is angry and I need to deal with this. And it was related to the guy with the tile. And my sister was a person that didn't back down. She felt she was right, she wasn't gonna back down. And so they had words back and forth and they argued for hours. Middleton Jr. was in the den doing his homework. And when that gun was pulled out, we were no longer on the phone because she had hung up. When Middleton Jr. was in the den, they were arguing back and forth. She was standing in the doorway. He was standing partially in the doorway. And his 11-year-old son watched him shoot his mother at point blank range in the head. So much so that the watch she had on had brain matter in it. The reason I know that is because my other niece gave me that watch after my sister died. And I noticed that there was something in there. And it was the matter from my sister's brain. The other thing I want to say is that Middleton did not call my mother to tell her what he did. We got a call about 11:30 that night from NOPD. I was there with my mother when the call came. And they said, we need to talk to your mother. There's something wrong with your sister. And I drove my mother to their house while the paramedics tried to revive my sister. And they weren't able to, they had her, she was conscious, but not fully. My mother rode in an ambulance with my sister to the hospital. And as she would say, she could hear my sister gurgling on her blood while she was trying to regain consciousness. They were not able to revive her. I never heard that story until the hearing 2 years ago. My mother's been living with me for years. She's with me now. That was my first time hearing that story. My story was that I went with Middleton Jr. to the police station to give his account of what happened. And he shared his story of how his dad shot his mother in the head. Not by accident. The gun didn't fall, as he tried to say. There was nobody on the scaffold when they were doing construction on the house. None of those stories were true. When they called when Lil Milton, he didn't call 911, Lil Milton did. And when he called 911, he tried to get him to tell them it was an accident. But it wasn't an accident because he had pulled the gun on her many times and held it to her head. And as she would tell us, playing Russian roulette. This is not a one-time situation. My mother and I went many times to my sister's house. One time I went with my brother, my nephew, and my 2 babies. Because my sister called me and she said, Milton beat me with a baseball bat. And I can't stand up. I need you to call the police and get over here. And I went. And when I got to the house, he wouldn't let me in. And I told him, you're gonna get out of my way. And you're gonna let me get in there and check on my sister. Eventually he moved. When I got inside, he had a gun on the wall. And my nephew says to me, Auntie Sheila, he said, we have to leave right now. My daddy's gonna kill all of us. And I didn't know what to say to that. Because after I walked in there, I realized I put other family members in danger. So I said to my nephew, I said, your daddy loves you. He's not gonna kill you. And my nephew said to me, when my daddy is angry, he doesn't love anybody. Now, the way I know that story is because his previous wife was also abused and beaten and run out of the house naked. The way he started doing plumbing was he worked for Sewage and Water Board. He gambled with coworkers. One of them lost and didn't pay him. He went to work and beat that man with a pipe and he lost his job and then he became a plumber. Now, my sister said she forgave him. I had to, because I wouldn't have been able to live my own life if I hadn't. But forgiveness doesn't mean I want him released. Forgiveness doesn't mean he's even ready to be released. And I understand there have been a lot of good things that have happened. I'm not denying that. I'm glad. I'm glad he's teaching plumbing. I'm glad he's doing classes. I'm glad he's working on himself. But when you've had a lifetime of abusing other people, I just question whether it is the right thing. I also know it's not my decision. It's your decision. And you're gonna go away and you're gonna take in everything everyone has said. And what I expect is that you will vote your conscience. And it doesn't mean that you're gonna agree with me. But whatever your decision is, we're gonna accept it. We are going to accept it. And we're gonna walk away from here and still support our family, no matter what side of the aisle they're on, as we have for many, many years.
Thank you, ma'am.
Thank you.
Thank you very much. Does the mom feel like talking?
Yes, it's asking.
Okay, it's here. Miss Evelyn Sturgis.
Sure, that's fine.
Sure. Does it do my listen to me? Did you take?
Sure.
Morning.
Good morning.
My name is Beverly Sturgis and I'm a mother, Karen, my oldest daughter. Oh, this reminds me of the day that he killed my daughter. It was about 10:30 at night. And my other grandchild was at our house and he came in. I think I was ironing, getting myself ready for work the next day. And he told me, he said, Granny, he said, there's a phone call for you, it's the police. I laughed because we tease each other and I thought he was teasing me. And I said, Lord, police not calling me. And I knew I had never been in jail. I've never had anything to do with the police. So they called to tell me that something had happened to my daughter. But he wouldn't tell me what I tried to get him to tell me.
And he said to come over right away. And I was living, this daughter was with me. So she said, Mom, I'll bring you over there. When I got there, they had police cars all around, people out. And I tried to go in the house. They wouldn't let me in. They would not let me go in the house because I wanted to see her. I wanted to see what was wrong. And finally, after a long time, they came out and told me that she had been shot by my husband. And they still wouldn't let me go in, but they said they were trying to stabilize her before they take her to the hospital. And they never could stabilize her. So they brought her out, put her in the ambulance, and I sat in the front seat beside the driver. And they had her on the gurney on the side behind the driver of the ambulance. And I could hear some gurgling sounds and mostly probably death sounds. And it was so loud and so, I'll never forget that. I'll never forget that. When we got there, they took her and they put us in a room. And after we were in there a while, they came and said that she had passed. And they said they asked him, they said he would come and let me go and see her. And when I went in there, her eyes were wide open. And someone closed her eyes. And I could see the wound in her head, in the blood. And that was the most awful sound, most awful thing. And even when she was alive, sometimes she'd fall asleep with her eyes open. And I've never known anybody else that would happen to, but that would happen. And so when she passed, her eyes were open. I'll never forget that moment. But I've forgiven Milton too, long time ago, and it's not revenge. But I just pray that he talks about all the good stuff he's doing, and that's good. But when you kill somebody, you don't have remorse. I've never heard him say, I love my wife, and I'm sorry that I killed her. I'm sorry I took her away from our son. He was 11 years old, almost a baby, in a sense. And he went to jail. My daughter is dead, so that left him an orphan. He didn't have anybody. He didn't have either parent. So my oldest daughter, Linda, she took him to live with her. We went in New Orleans, and she was living in Texas. And she came and got him and took him to Texas and raised him. And she treated him like she treated her own children. She was like a real mother to him. And I just love him so much, and I was so sad to see him having to go through life knowing his dad killed his mom and loving his mom and can't have her here to be with. But
Thank you, ma'am. I know this is difficult.
I'm 96 years old. Who knows how long my daughter would live if she hadn't been killed. She may have lived as long as me. She may live 96 years or more. But I don't hate Milton. And I'm trusting in God. I prayed about this. I'm not gonna make a decision when he stays when he stays there or when they let him out. I'm trusting in God that when he make his decision, it's gonna be the right decision. And I'm not gonna try to fight it, I'm not gonna worry about it. As long as he don't come around me, I don't wanna be anywhere around him. But I pray that all the stuff that he learned, all the good things that he's done, that he will focus on that and not just do the right thing, just do what's right and make a good life and treat little Middleton like he should be treated and love him like he should be loved. He missed a lot of love from his mother and his dad. So he didn't think about when he killed his mom, that he wouldn't have any parents, that he was young enough that he needed somebody to take care of him.
Right.
And then he resented him being with Linda. He didn't want Linda. He didn't want him by Linda. But you're gonna kill his mom and you won't have a choice of where you want to live.
Yes, ma'am, we appreciate hearing
I'm
from
not
you
wishing
this
any
morning.
bad happened to him. Because I prayed, when I pray for him too. I pray for my family and I pray for him too. But I just want justice and like God forgives. But he doesn't say that you don't have to pay the consequences of what you do. You do wrong, just like a child. They misbehave, my daughters misbehave. I'll forgive them, I don't hate them, but I'm gonna punish them, let them know that that's not right, let them do the right thing to do. And I've taught them, even if the other person is doing wrong, you stand up for what is right. Even if you're the only one that's standing, you do the right thing.
Yes, ma'am. Ms. Sturgis, we need to move on, ma'am. I'm sorry. But Ms. Sturgis, I'm sorry, ma'am. Maybe, it's okay. No, we appreciate hearing from you, but we need to move on. We appreciate it. Thank you for your work.
Too good things to move on. Yes, okay.
Thank you. All right, now we're gonna come back to Mr. Milton.
Yes, ma'am.
So tell us, I think we've heard it, but how long you been in jail?
I've been incarcerated 32 years, 1 month, 1 week, and 4 days.
And you mentioned, I think Ms. Hutchinson mentioned the RSAT program and STAR program. You completed which of those, both? Or it's all the same?
We have RDAP in September of 2025 and then STAR throughout 2024 because they go through workbooks. On page 10, I have it listed out for you all, each one, because STAR is long-term, you get notice throughout as you complete each section.
11 months.
How many?
11 months.
11 months, okay.
Thank you. Well, there's been a lot said today by a lot of different people. And I will ask, I don't have any questions. I think the questions I have been addressed. Mr. Freeman has a question.
Did you serve in Vietnam? Did I see that?
Yes, sir.
Okay.
Yes, sir. I did an 11-month tour in Vietnam in 1969. I earned 3 medals in Vietnam. I earned a National Defense, Armed Force Expeditionary, and Vietnam Service Medal.
Saw that up there, and that's why I wanted to ask. Appreciate you,
Yes, sir.
sir.
Thank you.
So, Mr. Milton, we want to move on. Is there anything that you want to add that hasn't been said? Briefly, if you'd like to add anything, but be brief.
I want to say I'm sorry for the family. And I want to thank my children. I have all 3 of them here for support, for their forgiveness. And it means so much to me for them to just allow me to be able to talk to him. Not only talk to him, there's also extended an olive branch. They even want me to be a grandfather to my grandchildren and my great-grandchildren.
All right, I think we are, we're prepared to vote. I think Mr. Craig will be voting first.
Yes, sir. If I can get through this. Mr. Williams, I really appreciate all the supporters, and I appreciate those that came forward as the victim's family and all of that. These are tough decisions that we have to make. I really don't know. I don't know what else we could ask you to do that you didn't do. You've stepped up to the plate and done everything, and you're remorseful. I've seen that in what you've written. I've seen it in what you've said. And let's see Mr. Williams behind you that it's, I believe that was the one I called the granddaughter.
Dr. Mead.
Are you talking to Milton Williams Jr.? Which one are you speaking of?
No, the fella in the sweater.
Oh, Dr. Mead.
Dr. Mead.
I'm sorry, I couldn't. Okay. I just want to say, I appreciate your words too, sir. I take them very seriously because you're kind of like one of us. You just read a lot of information. You know him better than we do, but you don't really have that much of a dog in the hunt. And so I appreciate the words that you said and the way that you've been represented, Mr. Williams. My vote today is to grant your parole.
Thank you very much, sir.
Mr.
Okay, I sit here and we had a case just like this yesterday. We have the family on one side that are victims. We also have the children that are victims. So we sit here with split because we put a lot of emphasis on how our victims feel. And these victims here at headquarters are very loving, obviously. They all gave great statements and they all have stated that they would go by our decision because it's really in God's hand, which I think we all believe. But in today, I too also think you've done all that we can ask you to do while you're in Angola. And I'm going to also vote to grant to the parole project for a minimum of 1 year. I want him there for a minimum of 1 year to get reestablished, and also no contact with the other side of the family unless initiated by them. You're not to contact them unless they initiate it.
Yes, sir.
So good luck to you, sir.
Thank you very much.
All right, and Mr. Williams, I saw you at your last parole hearing, and I did suggest some programs that you would benefit from, and you've done that. I agree with my colleagues. I just don't know what else we could ask you to do. I think you're rehabilitated. I do not think you're a public safety risk. So my vote today also is to grant to the parole project transition plan. And just remember, no contact with any family member, Linda Smith, Sheila Craig, or Mrs. Sturgis, are their family members, spouses, children, whatever, unless it's initiated by them.
Yes, ma'am.
Take that very seriously if you don't do that. So good luck to you, sir.
Thank you very much.
Thank you, board.
Thank you.
So since my complete redo of OBS that had to happen last week, I don't have the stingers installed yet, but to be honest, I don't know if I would have played the approved stinger on this one anyways. I think Lindsay just said it best in the chat. You could ask him to serve his time. I agree. It's great that he's fixing himself, that he's trying to become better, that he's getting himself in as a man of faith, getting himself right for when he needs to meet his judgment. These are all good things, but that doesn't necessarily mean that just because he does all these good things that it's suddenly okay to just let him out for killing his wife. I don't know. I mean, we've talked so much about this board, and the reason why I show them is, there's good stories here. There are definitely stories of redemption, stories where your release is appropriate. And we definitely see this board make weird decisions. We've seen them struggle with decisions. It can't be easy. I've said it before, despite what we think about what they rule or don't rule, I wouldn't want their job. It's got to be difficult because, at the end of the day, no matter what they do, they're going to anger half of the people involved, no matter what decision they make. But this one struck me. I don't know that that this guy deserves to be out, but he's going to be. So hopefully, somehow, some way, he is a benefit to society because it's going to happen. So there you go. All right, folks. That's it for today. A little bit of overtime. I hope you enjoyed it. So tomorrow I will not be here. However, Michael Groff apparently is going to step up and guest host for us tomorrow. So we will be back 10 a.m. Eastern, 7 a.m. Pacific. 45. No, not 45 minutes early because we won't have a pre-show tomorrow. But yeah, 10 a.m. Eastern, 7 a.m. Pacific. Support Michael through Super Chats. Any Super Chats, Super Stickers always revolve to the guest host. So be sure to give him your support. And I'll be back with you Friday, 10 a.m. Eastern, 7 a.m. Pacific. So have yourselves a great Wednesday. Enjoy tomorrow. We will still be posting our regular videos and stuff tomorrow. That'll all still happen. But Michael will have the live show. And yeah, I'll see you again live on Friday. In the meantime, take care. God bless.